Yes, Mr. Das.
My lord.
What has happened?
My lord, so produce the husband, my lord. He has come.
What about that child?
A child is in custody of the my lord. He has also.
And where is the mother?
Well, mother couldn't come because her father suddenly fell ill. Yesterday night I talked to her, but this morning she said that her father is ill. So
we want to know that about the child's willingness to
yes,
stay in the company of the mother.
yes, and you
Otherwise,
have
your remedy lies elsewhere.
yes,
You have to file that petition, and that would be a detailed proceeding. Evidence is to be adduced, then appropriate order is to be passed. But here, for temporary reason, if even if one party is given the custody, the other party will have a visiting right.
visitation right. Yes.
So for that purpose, we wanted that let the child be produced and let the child spend some time
with the mother, so that after 1-2 hours further.
Not 1-2 hours. Let him. That is a what is that called? Functional. There is a specific house room which is meant for this children, and there they can spend some time. So that was the idea.
Yes.
For
Your lordship may grant me some little day.
Ask him to come. ତମେ ଯୋଉ ତମକୁ ପଚାରୁଛି ଯୋଉ ରହିଥିଲ କଣ ଅସୁବିଧା କଣ ହେଲା କାହିଁ ସେ ରହିବାକୁ ରାଜି ହେଲାନି?
ସେ ରହିବା ପାଇଁ ଚାହୁଁନି, ପ୍ରତି ମୋମେଣ୍ଟରେ ମିସ୍ ବ୍ୟବହାର ଦେଖଉଛି। ଦୁଇରେ ବି
ସେ ମାଇକ୍ ଟିକେ ଆଡଜଷ୍ଟ କର। ତମକୁ ଏତେ ସୁବିଧା କରାଗଲା, ଭଡା ଘର କରାହେଇକିନି ସମସ୍ତ ପ୍ରକାର ସୁଯୋଗ ଦିଆହେଲା, ଏକାଠି ରହିଲେ ଛୁଆଟାର ଭବିଷ୍ୟତ ହବ। ତମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ତମର ତିକ୍ତ ସମ୍ପର୍କ ରଖିବ, ସେଇ ଯୋଉ ପିଲାଟି ସଫର ହଉଛି ନା, ତାର ଭବିଷ୍ୟତ ଅନ୍ଧାର କରିଦଉଛ ତମ ମାନେ। ସେ ଭୁଲ କାହାର ଅଛି ସେଇଟା ହଉଛି ଅଲଗା କଥା। କାହାର କେତେ ଭୁଲ ଅଛି କି ଉଭୟଙ୍କର ଭୁଲ ଅଛି ଯୋଉଥିପାଇଁ ତମେ ଏକାଠି ରହିପାରୁନ, ସେଟା ଅଲଗା କଥା। କିନ୍ତୁ ଯେହେତୁ ସେ ଛୁଆଟା ସଫର କରୁଛି, ସେଇଥିପାଇଁ ତମକୁ ଦାୟିତ୍ୱ ଦିଆଗଲା ଯେ ଏକାଠି ରହିବ। ତାପରେ ସେ ଛୁଆଟା ଯାହା ତାର ଜେଜେବାପା ଜେଜେମାଙ୍କ ପାଖରେ ରହୁଥିଲା, ତାକୁ ଆଣି ପାଖରେ ରଖିବ। ଏଇ ସବୁ ଉଦ୍ଦେଶ୍ୟ ନେଇକିନି ଏତେ ବନ୍ଦୋବସ୍ତ କରାଗଲା। କୋର୍ଟ ତାଙ୍କର ସମୟ ଦିଆହେଲା, ସବୁ ପ୍ରକାର ଅର୍ଡର ହେଲା। ତାପରେ ବି ତମେ ଏ ଟାଇପର ଯଦି ଆଚରଣ କରିବ, କଣ କରାଯିବ?
ଆଜ୍ଞା ସେ ଚାହୁଁନି ମୋ ପାଖରେ ରହିବା ପାଇଁ, ପ୍ରତି ମୋମେଣ୍ଟରେ
ସେ ଯାଇ ରହିଥିଲା। ସେ ଯୋଉ ଆର ଅର୍ଡର ପରେ ସେ ଯାଇକି ରହିଥିଲା। ତମେ ଯାହା ସବୁ କରିଛ ସେ ଲେଖିକି ଦେଇଛି।
ଆଜ୍ଞା ସବୁ ମୁଁ ତାର ଯାହା ଆପଣ କହିଥିଲେ, ଆପଣଙ୍କ ଅନୁମତି ଦେଇକି ମୁଁ ସବୁ କାର୍ଯ୍ୟ ସବୁ ଯାହା ଯାହା ଦରକାର ମୁଁ ସବୁ ଦେଇ
ତମେ
ସାରିଛି।
ଯାହା ତାକୁ ବ୍ୟବସ୍ଥା କଲ,
ଘର ଭଡା ଯୋଉଠି ନେଇଥିଲା ସେଇ ଘର ଭଡା ବାଦ ପାଇଁ ମତେ ଟଙ୍କା ମାଗିଲା। ମୁଁ ଅନୁମତି କଲି, ମୁଁ କହିଲି ଏଇ ଟଙ୍କା ମୁଁ ଦେବି ନାହିଁ। କୋଉଠି ଘର ଭଡା ନେଇଛ ତା ବ୍ୟବସ୍ଥା ଟଙ୍କା ମୁଁ ଦେବି ନାହିଁ। ତାପରେ କହିଲା ମତେ 20-30ଟା ପିଲା ଆଣିକି ଦିଅ, ମୁଁ ଟ୍ୟୁସନ କରିବି। ମୁଁ କହିଲି ସେଟା ତ ଲେଖା ହେଇନି ଟ୍ୟୁସନ କରିବା ପାଇଁ ନା। ଆଜ୍ଞା ଏନି ଟାଇମ ପ୍ରତି ମୋମେଣ୍ଟରେ ଫୋନ ଉପରେ ଫୋନ ଗପା ହଉଛି। ତାପରେ ମୁଁ ସାର୍ଙ୍କୁ ଆସିକି ଆବେଦନ କରିଥିଲି, ଆଇ ସାର୍ଙ୍କୁ ମୁଁ କହିଥିଲି ସାର୍ ପ୍ରତି ମୋମେଣ୍ଟରେ ସେ ଫୋନ ଫାନ କରୁଛି, ଆଉ ମନା କଲେ ସତେ ବି ସେ ମିସ୍ ବ୍ୟବହାର ଦେଖଉଛି। ତାପରେ ଥରକୁ 5 ଥର ସାର୍ଙ୍କୁ ଆସିକି ଆପତ୍ତି ଅଭିଯୋଗ କରାହେଇଥିଲା। ମୁଁ ବି ସାର୍ଙ୍କୁ ଆପତ୍ତି ଅଭିଯୋଗ କରିଥିଲି। ମୁଁ କହିଲି ଯଦି ଏମିତି ନ ଶୁଣିବେ ତାହେଲେ ମୁଁ ଲିଖିତ ଆକାରରେ ଜଣେଇବି ବୋଲିକି।
ଛୁଆ ବର୍ତ୍ତମାନ କୋଉଠି ରହୁଛି?
ଛୁଆ ବର୍ତ୍ତମାନ ପିତାମାତାଙ୍କ ପାଖରେ ରହୁଛି। ପିତାମାତାଙ୍କ ପାଖରେ।
ପିତାମାତା ମାନେ ମାନେ ତାର ଜେଜେମାଙ୍କ ପାଖରେ?
ଜେଜେବାପା ଜେଜେମା ମୁଁ ରହୁଛୁ। ଆଉ ଘର ଭଡା ଆଜ୍ଞା ପଇସା ହେଇଯାଉଛି।
ପାଠ ଆରମ୍ଭ କଲାଣି?
ଆଜ୍ଞା ପାଠ ପଢୁଛି ଆଜ୍ଞା।
କୋଉଠି ପଢୁଛି?
ଅଙ୍ଗନବାଡିରେ ଆଜ୍ଞା।
ତମେ କଣ କର?
ଆଜ୍ଞା ଲେବର କାମ କରେ ଆଜ୍ଞା।
जदि तमर पिला मानू से पाठ पढ़ौथिला से जदि पाठ पढ़ेवा जदि अन्य छुआ को चाहूची पाठ पढ़ाऊ तमर असुविधा कौन होची?
से डायरेक्शन मु ता डायरेक्शन आगे चले
सबू डायरेक्शन कोड दब ना
ना ना आगे से जो डायरेक्शन करछन से डायरेक्शन संभव नहे। से
कौन
कहउछन्ती मो तांको घरे रहिया पे से जाउची मो बाकी रहबिनी से कहउची सेठी रहिबो
से पई नुए सेठी पई गोटे भड़ा घर तमे नेलो से
आज्ञा,
जे
आज्ञा।
रहिला से सब अछि
आज्ञा
जदि सीए कहउची मु पिला मानू को ट्यूशन करेबी भलो कथा तादेर आपत्ति कोन अछि?
आपत्ति बेले ट्यूशन कोठु आनिबे पिला आज्ञा मु ट्यूशन
तमु से कोन कहउची
आज्ञा
तमु से कहउची
आज्ञा
पिला
से
जुगाड़
कहउछन्ती
करे
मते पिला जुगाड़ करिकि दिया मु ट्यूशन करिबी
सी जदि तार ट्यूशन कले तमर किछि आपत्ति नाही तो सी तार पिला जुगाड़ करिवो कि कोन करिवो
से
तमर किछि
पिला जुगाड़ करे हेतरे मोर किछि आपत्ति नाही हेले मु जोठे अछि जो एरिया रे पिला मु कोठु आनिबे से कहउची तांको
हो
गां
तमु किए कहउची पिला जुगाड़ करियाउ
आज्ञा
सी तार जदि ट्यूशन से पाठ पढिछि पिला मानू जदि पाठ पढिया चाहूची
हां
ताले असुविधा कोन रे?
नाही मोर किछि आपत्ति नाही आज्ञा
ଦି ପଇସା ରୋଜଗାର ହେଲେ ତମକୁ ବି ସାହାଯ୍ୟ ହବ।
मोर किछि आपत्ति नाही एथरे से जदि घरे ट्यूशन करिया पे जाउची मोर किछि आपत्ति नाही आज्ञा
तमे
ତମକୁ ଯୋଗାଡ଼ କରିବାକୁ
तमे
मते से कहउछन्ती जोगाड़ कर पिला
तमे लेबर काम से यदि करूची तमे लेबर काम करियाउ जदि जाली जाउछ तापर जो समय मिलुची से सेही समय रे पिला मानू पढेबो कि कोन करिवो तार
हां
असुविधा
निश्चित
तो किछि नाही
नाही सेथरे मोर ऑब्जेक्शन नाही
ते तम कि आछनी तमरो तम
विकास
डाकन डाकन आपण कोन करंदी माइक पक माइक पकसन
काठर काम दाम करे
हां
आज्ञा
आ पिलाडा कोठी बर्तन आपण पाखे रहउची
आज्ञा
कोन सर पढ़ा पढ़ी अन्यान्य व्यवस्था
आज्ञा
कोन
पिलाକୁ ବର୍ଷକ ଜନ୍ମ ତାରିଖରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଜେଜେମା ଜେଜେବାପା ଆମେ ତାକୁ
केते वर्ष तक गलाणी?
ଆଜ୍ଞା 6 ବର୍ଷ 6.5 ବର୍ଷ
हां से कोठी पढुची तब
ଆଜ୍ଞା ଅଙ୍ଗନବାଡିରେ ବର୍ତ୍ତମାନ ପଢୁଛି
ତା ସବୁ ଜିନିଷ କି ଇଏ ତ ପଳେଇ ଯାଉଥିବ କାମକୁ
ଆଜ୍ଞା ଆଜ୍ଞା
କିଏ ବୁଝାବୁଝି କରୁଛି
ସାର୍ ସବୁ ଜେଜେମା ଜେଜେବାପା ଆମେ ବୁଝୁଛୁ
ଆଉ ବହୁ ସାଙ୍ଗରେ ରହିବାକୁ କଣ ଅସୁବିଧା କଣ ହେଲା କାହିଁ ସିଏ ଏକୁଟିଆ ରହୁଛି ସିଏ?
ସାର୍ ସେ ପୁଅକୁ ଟୋଟାଲ ପସନ୍ଦ କରୁନି ସେ ଯେତେବେଳେ ପିଲା ବର୍ଷକର ହେଇଥିଲା ସେ ଛାଡିକି ଅନ୍ୟ ପୁରୁଷ ସାଥିରେ
ଏଇ
ପଳେଇଲା
ଯୋଉ
ଆର କରୋନା ହେଇଥିଲା
ମା ପାଖରୁ ପିଲାଟାକୁ ଅଲଗା କରି ରଖିଛ ତମ ମାନେ?
ନାଇଁ ସାର୍
ଆଉ ନୁହେଁ ଆଉ କଣ
ନାଇଁ
ସେ
ସାର୍
ମା ଚାହୁଁଛି ପିଲାଟିକୁ ପାଖକୁ ଆଣିବାକୁ ତମ ଇଏ ବି ଯାଇକିନି ରହନ୍ତେ ଏକାଠି ରହନ୍ତେ ପିଲାର ଭବିଷ୍ୟତ ହୁଅନ୍ତା ତମମାନେ ତା ଦେହରେ ସହଯୋଗ କରିବ ନା ତାଙ୍କ ଭିତରେ
ଆଜ୍ଞା
ତିକ୍ତତା ଆହୁରି ବଢେଇବ?
ପିଲାଙ୍କୁ ମୁଁ ଛଡେଇକି ରଖିନି ଆଜି ପର୍ଯ୍ୟନ୍ତ ପିଲାକୁ ଚଳେଇକି ବଢେଇକି ଆସିଛି ବଢେଇଛି 5-6 ବର୍ଷରେ ଆମେ କରିଛି ନିଜେ ମୁଁ ପିଲାକୁ ଛଡେଇବି କଣ ମଣିଷ 5-6 ବର୍ଷ କରିଛି
So, Mr. You produce that, you let that lady comes unless
Yes.
she comes. Otherwise, you will simply dispose of the matter that you take appropriate.
Your Lordship may grant me some time, fix another date.
February, so in the we are fixing this case to on 23rd February 2024. You appear and
ସେଦିନ ନ ଆସିଲେ it will be
we will
disposed.
dispose of the matter. ପିଲାର ଯେମିତି ବର୍ତ୍ତମାନ ସେ ମା ପାଖରେ ନାହିଁ ସେ ମାତୃ ସ୍ନେହରୁ ବଞ୍ଚିତ ହଉଛି ତେଣୁ ତା ଦାୟିତ୍ୱ ଆପଣ ମାନଙ୍କ ଉପରେ ସେ ପିଲାକୁ କେମିତି ଭଲ ମଣିଷ ହବ ତାକୁ ଦେଖିବେ ପାଠ ପଢାରେ ଯେମିତି କିଛି ଅସୁବିଧା ହବନି ତାର ସ୍ୱାସ୍ଥ୍ୟ ତାର ଖାଇବା ପିଇବା ଏସବୁ ଜିନିଷ ବୁଝିଲ ନା ନାଇଁ ତମେ ତେଣୁ ବାପା ମା ଦିଟା ଦାୟିତ୍ୱ ତମ ଉପରେ ରହିଛି ହେଲା କୌଣସି ପ୍ରକାର ଯେମିତି ଅବହେଳା ହବନି ତାକୁ ଦେଖ ଫୋନ ଇଏଟା ଦେଲେ ମାଇକ ଟା ପଚାର ପୁଅ ତ ପୁଅ ନା ଝିଅ?
ପୁଅ
ପୁଅ ମାଇକ ପଡେ କଣ ନାଁ କଣ ତମର?
ସୁବ୍ରତ ମହାରଣା।
ସୁବ୍ରତ
ମହାରଣା।
ଆଚ୍ଛା ଆଉ ପଢାପଢି କରୁଛ କୋଉଥିରେ ପଢୁଛ?
ଅଙ୍ଗନବାଡ଼ିରେ।
ଆଚ୍ଛା କୋଉ ଶ୍ରେଣୀରେ
ହୁଁ
କୋଉ ଶ୍ରେଣୀ ଅଛି ନା ନାଇଁ?
ନା
ଆଚ୍ଛା କେବେଠୁ ପଢୁଛ?
3 ଦିନ
ଆଁ
3 ଦିନ
କଣ କହୁଛି?
3 ଦିନ।
ଆଚ୍ଛା କିଏ ଯାଆନ୍ତି ନେଇକି ଛାଡିବାକୁ ଅଙ୍ଗନବାଡିକୁ?
ମୋ ବା
ବା ମାନେ କିଏ?
ବାପା
ଆଚ୍ଛା ତମ ବାପ। ଆଉ ତମ କଥା ସବୁ କିଏ ବୁଝାବୁଝି କରୁଛନ୍ତି ଘରେ ରହିଲା ବେଳେ ସେଠି?
ମୋ ବା ମୋ ସତ୍ୟ ବାପା ଆଉ ମା।
ବୁଝୁଛନ୍ତି ବୁଲାବୁଲି କରିବାକୁ ନଉଛନ୍ତି? ଆଉ ଘରେ ପାଠ ପଢିଲା ବେଳେ କିଏ ପଢଉଛି ତମକୁ?
ବଲିଆ ଭାଇ
କିଏ?
ବଲିଆ ଭାଇ
ସାହିରେ ପିଲା ଗୁଡା
ଅଲିଆ ଭାଇ।
ଆଚ୍ଛା
ମା କଥା ମନେ ପଡୁଛି? ନାଇଁ
ମା ସାଙ୍ଗରେ ଗତ ଥର ଦେଖା ହେଇଥିଲା। ମା ପାଖରେ ଯାଇ କିଛି ଦିନ ରହିବ ଯାଇକିନି। ବାପା ମା ତମେ ଏକାଠି ରହୁନ? ମା ତମକୁ କେତେ ଭଲ ପାଉଛନ୍ତି, ତମ କଥା ମନେ
ବାପା ମା
ପକଉଛନ୍ତି।
ଯୋଉ ଏବେ ଥିଲେ ତମ ବାପା ମାଙ୍କ ପାଖରେ ଥିଲ ଟି?
ନାଇଁ ସେ ଆସିଲାନି।
ଗୋଟାଏ ଦିନ ପାଇଁ 10 minutes ପାଇଁ ଆସିଲା, and that is also one of the reason for dispute.
ମା ମନେ ପଡୁଛନ୍ତି? ନାଇଁ
Right. The
ମା ଗୋଡ କାନରେ କଣ ସେଟା ଲାଗି?
ଦାନ୍ତ ପୋକ ଖାଉଥିଲା।
ପୋକ ଖାଉଛି ସାଙ୍ଗରେ ଫୁଲିକି ରହିଛି।
ଦାନ୍ତଟା ପୋକରେ ଦାନ୍ତ ଡାକ୍ତର ନଉ ନା କାନରେ କଣ ଲଗେଇଛି?
କାଲି ରାତିରେ ଆଜ୍ଞା ହେଇଥିଲା ଯେ ଆଜି ସକାଳୁ ସକାଳୁ ଇଆଡେ ଆସିଲେ ତ ମେଡିକାଲ ନବା ପାଇଁ ଏପଟେ ଦେଖା
ଏଇଠି ଶିଶୁ ଭବନ ଅଛି, ତାକୁ
ଆଜ୍ଞା।
ନେଇକିନି ଯାଅ ହେଲା।
ଆଜ୍ଞା
କଣ ହେଇଛି ଦେଖାଅ। There was a direction for the IAC Khanpada police station. Who is anyone present or is? Who is he? Please give the name and designation. Is the IAC?
You are Mr. Jyoti Prakash Pai?
ସାର୍
IAC Khanpada.
Right. ସେଟା କାହିଁ ସେ ଦୋକାନରେ? As per the order dated 8/1/2024,
ଥାଉ
Mr. Jyoti Prakash Swain, Inspector in charge of Khanpada Police Station, produced the opposite party number 1, Satyanarayan Maharaj, before this court. Chairperson, Child Welfare Committee, Nayagar. Was also asked to produce the child before this court as per the said order, and the child was produced. On being questioned, the child stated to be living happily in the company of his father and grandparents, and going to attend schooling in Anganwadi center. He further stated that he is facing no difficulty in staying with his father and grandparents. The opposite party number 1 stated that in spite of all arrangement being made by him to stay in the company of the petitioner. As per the orders of this court, the opposite party left the rented house on her own accord within a few days of their staying together. He stated that the petitioner compelled her to arrange some student for tuition purpose, which was not possible on his part. And that was the main reason for which the petitioner left his company. Land Council for the States of Parapuri produced the letter of the IIC Khandapada Police Station dated 24/1/2024. So also the letter dated 19/1/2024. So also the order number 4 dated 19/1/2024 passed by the Chairperson Child Welfare Committee Nagar, which are taken on record. The Land Council for the petitioner submits that the petitioner is facing difficulty today, for which she is not able to attend the court. And another date may be fixed for her personal appearance. In view of such submission made, we fix the next date to 23rd of February 2024.
23 February
The matter
ଛୁଆକୁ
will,
ନେଇକି ଆସିବ
the matter will be
Saturday,
taken up at 10 a.m. The Child Welfare Committee now allow the child to stay in the company of her grandparents and father in the house of the opposite party number 1. The inspector in charge of Khandapada Police Station shall release the petitioner on PR bond with condition that he shall appear in person with the child on 23rd February 2024. Copy of the order be handed over to the Land Council for the state for compliance. Personal appearance of the inspector in charge of Khandapada Police Station is dispensed with. Say, needless to say that the petitioner opposite party number petitioner remains absent on the next date, appropriate order shall be passed. तो आजी ऑर्डर हैला जे फेब्रुआरी मास 23 तारिख शुक्रवार दिन 10:30 रे तमे छुआ को धरी कोर्ट रे उपस्थित रहइबो तम स्त्री मध्य आसीबे से दिन हला से दिन केस रो परवर्ती सुनानी हबो से पर्यंत छुआ तार तम पाखरे आ तार जे मां को पाखरे रहिबो हला आउ इंस्पेक्टर इन चार्ज को गोटे बॉन्ड देकिन तमे जीव जे तमे जेमती हेले 23 तारिख दिन उपस्थित होइकी रहइबो नचे तम विरुद्ध रे भी कार्यानुष्ठान ग्रहण करा जी लिखि दियंतु इफ इज नॉट इंस्पायर्ड doesn't remain present appropriate action will be taken आपने होचे आप
ମୁଁ ଯୋଉ ଘର ଭଡା ନେଇଛି ସେ ଘର ଛାଡିବା ପାଇଁ ଚାହୁଁଛି ଆଜ୍ଞା କାହିଁକି ନା ଘର ଭଡା ଯୋଉ ନେଇଥିଲେ ଘର ମୁଁ ଛାଡିଦେବା ପାଇଁ ଚାହୁଁଛି ଆଜ୍ଞା ଲସ୍ ରେ କରି
the
ପଇସା
as a like the petitioner submit the opposite party number 1 submit that since the petitioner is unwilling to stay in his company he may be permitted to leave the rented house permission is granted start the other call
Item 2. May please your lordship. Lordship, the present appellant had been convicted by judgment dated 3/7/2010. Your lordship, the appellant had been convicted by judgment dated 3/7/2010, passed by the ad hoc additional session judge Balasur, your lordship, and had
why
been
this matter has come for bail purpose
yes, your lordship. Your lordship,
but so that will be good हाँ से हमें रिजेक्ट करथलु बोधे से इतने आस्तियो
we filed an interim application 28 of 2000.
Justice Vinod Prasad. It was rejected on 29. But it is a 2010 criminal appeal and the paper book is ready.
Yes, your lordship.
So why don't you argue the matter?
Your lordship, we are ready with the.
You are ready?
Yes, your lordship.
We will hear it today.
Your lordship.
Okay, just wait. But you need to case को क्या है? इधर बहुत सारे मुतासर सोनू 2008 में बहुत कुछ मासी 10% में assignment अच्छी yes next matter Mr. Mishra, you are ready in this? Oh.
Item 3.
See, prayer for restoration of the
Yes, just a minute. Yes, we directed you to serve a copy of the
my
interim.
lord, I have already served the.
I am for the opinion for
For
Actor
this.
General.
So what have you got to say on this delay condonation? The delay is around 1573 days. A wrong submission was made that the petitioner is dead by the Learned Counsel for the petitioner who was approaching then. Petitioner is a judicial officer and he retired from his service and he claimed some benefits, pensionary benefits, etc.
Revised pension.
Huh?
Revised gratuity amount. Lordship.
So, any objection or?
Lordship, restore the application.
All right. Please give your name and
S.K. Patra.
what is it is CGC or central government?
No.
Please
Standing Counsel for the Accountant General.
please write down so that we can put it as per the order dated. As per the order dated 8/1/2024. The Learned Counsel for the petitioner has served a copy on the Learned Counsel appearing for the opposite party number 4, that is Accountant General A and F Orissa.
A and E, not A and A.
A and E.
E.
A and E to?
My lord.
Accounts and entitlements.
Wrongly typed as
A and E Orissa Bhubaneswar and Mr. S.K. Patra, the standing counsel or standing counsel, enters appearance for the said opposite party number 4. In this,
state government will decide.
no, that's a different matter. But you are a party in the main application, and you also filed 2 counter affidavits. That is why we thought it proper to hand over a copy, because this interim application has been filed under Section 5 of the Limitation Act for condoning the delay in filing the CMAPL. Which has been filed for recall of the order dated 22/2/2019, passed in WPC number 9503 of 2007. The prayer in the writ petition was for payment of death cum retirement gratuity to the petitioner at the revised enhanced rate at rupees 3.05 lakhs, with further direction to pay interest at the rate of 7% on differential amount of gratuity as admissible from the date of retirement, that is 21/5/2001. When the matter was taken off on 4/2/2019, submission was made by the London Counsel for the petitioner that the sole petitioner has died in the meantime, and on the basis of such submission, this court directed the steps to be taken for impleading the legal heirs of the deceased petitioner within 10 days, failing which writ petition would be dismissed without further reference to the bench. And accordingly, Deputy Register Judicial of this court dismissed the writ petition, since no steps were taken to implead the legal heirs of the deceased petitioner. Land Counsel for the petitioner submitted that the submission which was made by the London Counsel for the petitioner on 4/2/2019, that the sole petitioner has died, was not a correct statement. In fact, the petitioner is alive. We use the objection to the limitation petition filed by this objection has been filed by whom? By the state.
By state.
By the state. No objection has been filed by the opposite party number 4. After going through the averments made in the interim application, the objection filed by the Land Council for the state, and hearing the Land Council for the respective parties, we are inclined to condone the delay in filing the CMAPL. Accordingly, delay is condoned, IA is disposed of. Now, CMAPL number 450 of 2023. This application has been filed for recalling the order dated 22 to 2019. In view of the facts enumerated in the IA number, in the order relating to disposal of the IA number 171 of 2023. And the surrounding circumstances under which the writ petition was dismissed, and taking into account the averments made in the CMAPL, and the fact that the Learning Council for the state as well as the Learning Council for the opposite party number 4 had no serious objection in the restoration of the writ petition, we restore WPC number 9503 of 2007 to file. Matter be placed before the assigned bench. CMAPL is disposed of. Hello?
Much obliged.
Yes.
May I please your lordship? Sir, I am appearing for the pit.
Yes, sir.
May I please your lordship? The husband of the petitioner,
Hmm?
the husband of the petitioner has been missing from his working place since 2011.
Hmm.
And, he was
No,
transferred from Raulkela
you have
to.
filed this writ of habeas corpus for tracing out your missing husband.
Yes, my lord.
But how it writ of habeas corpus is maintainable? There is decision of Honorable Supreme Court and this court also that for a missing person, habeas corpus is not maintainable. Unless it's a case of detention, unauthorized detention, wrongful detention, habeas corpus is not maintainable. Missing person, habeas corpus is not maintainable. And we are also seeing your second prayer regarding getting benefit of the other things that can only be done if you prove in view of section 108 of the Evidence Act that for 7 years your husband is not hard of living. So a declaratory suit is to be filed before the appropriate civil court. That declaration has to be obtained. Then your husband is to be deemed to meet a civil death. The 108 of the, are you aware of that
A
provision?
civil death declaration I have
Right.
to file.
So thereafter you can get the benefit which your, as you have mentioned that rehabilitation appointment, etc., etc. But that you have not done. You have come to this court this relief, and we have also issued notice now they have taken a number of steps, and last date also they said that 11 years pending, and they said that it is not.
It filed the additional affidavit where they have stated that
The report is that the chances of tracing the missing person Kishore Chandra Tudu is very remote.
very remote.
That is the any further affidavit has been filed.
No, another one direction is there. File that. I'm filing it now.
Any development made, if any, tell or same position.
Recently, I have not taken any instruction because it was it has come after a long time, my lord. Previously, it was ready to file on that.
This we are pointing out that line.
Yes, my lord.
This is that the chance of tracing the missing person are very remote.
They have to have not received any.
Petition, and for the other way, he has to take appropriate remedy in the civil court. Declaration and after that, you really put up a price this
Only I minutes so that they may pursue that you file the status report and the final form regarding the missing of. I have already filed the FIR.
you can take the averments in this. You see, when you file their petition for declaratory suit, you are to say also there is a provision that within what period you are to file. 141, I think that limitation act, it says that within 3 years from that date, 7 years to, you are to file that provision. So you are to now explain the thing, explain in the sense that I approach the honorable court and the matter was pending, disposed of. So that would be a ground to condone the delay. All necessary things will not be. That is to be taken care of by. We are giving liberty to seek appropriate remedy before the concerned court for that declaration, because unless you get that declaration, you cannot get the benefit which you have sought for in this second sub paragraph, right?
Puspa Gaurang's case that I have relayed, I have already supplied the copy. It's available. And another is also Chanchala case that only the petitioner if the missing in the service during the working hour. And the one.
Mr. Counsel, for that, the factual scenario may be different. Unless the declaratory suit is filed, unless it is observed that your husband has met civil death, because there some other persons are to be party and your family members are also to be examined. The court has to give a finding thereon. That these are all the
right. Only the decision of our Honorable High Court I have relayed that only if the person is missing from the during the duty period and an investigation, so far as the copy I have obtained last occasion, that they have inquired from the peon and fourth grade employees, and he is a driver. I'm sorry.
That remains for 11 years. The court is monitoring this matter, and they have whatever they have done, that is their what steps they have taken. Now the affidavit has come that the chances of tracing the missing person is very remote. So they have conducted inquiry at different places, probable places of Visakhapatnam, etc., that they have been visited. Phone details have been collected. All steps have been taken. Now they are unable to find out. So and man missing entry अछि विभिन्न पुलिस स्टेशन को कांटेक्ट करिसेंती एई सब ये करिकिनी एठी subsequent relief yes, 8 point they were liberty analysis and then tracing of the missing petition says that our division petition relying on that is not maintained. Like you don't.
May premises without insisting to file the further information from the police officers. That
You rely on these.
Smile. You know,
ଏଗୁଡାକ ଆପଣଙ୍କର trump card ହବ ତାକୁ for declaration of that in the declaration you must have received the copy.
Yes, I have received.
You will take the grounds that it was pending before that court and the direction was given, they inquired into and given this type of affidavit. So that that would be a ground for you to get relief in that suit.
Yes, sir.
This writ petition has
I am appearing for the OP number 3 and 4.
Okay. Has been filed with following prayer. The prayer number first paragraph or second paragraph to highlight कर देंगे. It is therefore to up to the second paragraph. The petitioner is the wife of the missing person, that is Kishore Kumar Tudu, who was working as a mobile driver in the office of Odisha State Civil Supplies Corporation Limited, Sundargarh, in the year 2011, and he was transferred to Rayagada, the office of District Manager, OSCSC Limited. But since the date of joining at Rayagada, that is on 14/3/2011, he was not traced out. The petitioner approached the police authorities and other government officials of the concerned department for tracing out her husband. But no fruitful result came out, for which he approached this court. The matter was taken up by this court on various dates, and counter affidavits have been filed. And reports were submitted by the inspector in charge of Rayagada police station. Today, the Land Council for the state has filed an affidavit on behalf of the opposite party number 5, in which various steps taken to trace out the missing husband has been enumerated in detail. And it is stated further that even though sincere and all possible measures were taken against the missing person, but there has been no result, and the chances of tracing the missing person is now very remote. The affidavit is taken on record. In the case of In the case of so and so जो missing person ना से जो आमर decision टा अच्छी Supreme Court decision को rely कर सेटा quote कर दूँ. That since it's the case of missing person, the first prayer made in this writ petition for tracing out the missing husband, no relief can be granted to the writ petitioner. So far as the second prayer is concerned, the learned counsel for the petitioner submits that in view of Section 108 of the Evidence Act, he has to file a declaratory suit before the appropriate court, declare the civil death of the husband of the petitioner, and since there is delay in filing of such suit, the concerned court may be directed to take a liberal view and condone the delay in filing such suit, if any, taking into account Section 14 of the Limitation Act. The learned counsel for the state has no objection. In view of such submission, we dispose of the WPCRL, giving liberty to the petitioner to approach the civil court for filing the declaratory suit in accordance with law. And if any application is filed for condoning the delay, the concerned court shall take into account the pendency of the writ petition before this court since 2012 onwards and pass appropriate order in condoning the delay to entertain such suit. With the aforesaid observation, the WPCRL is disposed of. Party number one so is present also. The 3 and 4 may go on.
Item 5.
Last will please refer to the order dated 11/12/23. Honorable Court directed the state to produce certain records. Yes, Mr.
Lordship, the records are on the last occasion, the instruction that we had received was the records were with the Commissioner Bhubneshwar, Barampur, Your Lordship.
Yes.
Lords, now the development we've received is that, Lordship, since 2012, the records have been in the custody of the collector, Kandhamal Phulobani. So, Lordship, I pray for 2 more weeks' time, my lords.
On kaha par
Lords,
collector?
the collector, Kandhamal Phulobani, Your Lordship. Since 29th February 2012, the records have been.
All right.
Lordship.
Administrator S.S.Rao and Senior Advocate Mr. D.R. Bhupta and Central Government Counsel and Mr. Mishra, Sunuk Misral and an additional standing counsel. who submitted that though on 11/12/2023, 2023, a submission was made on his behalf that the records of settlement revision case number so and so सेटा mention है जिसे order है ना, have been shifted to the office of major settlement operation, Berhampur. However, the present development is that those records are available in the office of the collector, Kandhamal Fulbani, and the more time be granted, 2 weeks time, more time be granted for tracing out these records and producing the same before this court put up this matter in the week commencing from 19th of February 2024. Yes.
Public.
Item 6.
Millard, I am appearing from BC. I may kindly be allowed.
No.
Item 6, Millard. Millard, here the case, in the case I have filed the rejoinder affidavit and the case of Millard premature release. My Lord, kindly recollect the order dated 25/9/2023. My Lord was pleased to pass an order and also please to observe that the state has raised one point that now the scheme is not available, where recently, as per their counter affidavit, I may refer to the counter affidavit, Millard. That counter affidavit, Millard. Annexure E/3.
Wait. So what you have stated in your rejoinder affidavit?
Millard, rejoinder affidavit, I have stated that the
Just a minute.
That, yes, kindly see, I'm humbly see, my lord, page 5, para 6, my lord.
Wait. अठावन पेज जाए स्कैनिंग ହେଇଛି ତାପରଠୁ ଆଉ ହେଇନି। Yes, what you have stated in your
My lord.
affidavit.
My lord, I have stated humbly, my lord, submit that the SP has mechanically acted and also, my lord, violated the own guideline which he relies, that is 2022 guideline. Humbly, my lord, submit para 6. If, my lord, the guideline is, my lord, relied by the state where the SP, my lord, Superintendent Police, my lord, relied the statement of the, my lord, the IIC, which was, my lord, done by the IAC, he just, my lord, copied the same and without application of mind, my lord, he has relied this. I may permitted to say that somebody replied that as per resolution under annexure E by 3 of the counter affidavit, as relied by the opposite party, that the circular guideline of law department Odisha under section 7(4)(b) of the guidelines for premature release 2020-22. The SP Raurkela has not complied the above guideline and mechanically relied the report of IIC Raghunathpalli PS and without application of mind, he just made a copy paste of the same report of IIC Raghunathpalli PS and not in favor of the premature release of the petitioner. Kind perusal of this report, the relevant provision of the resolution is quoted hereunder. Circular 7, Millard. 4A. That is already annexure, blood, your state has filed. On receipt of the reference mentioned in clause B of subpara 3 of the concerned superintendent of police shall cause an inquiry to be made in the matter through a senior police officer of an appropriate rank and based on his own assessment shall make his recommendation, and while making the recommendations, the superintendent of police shall not act mechanically and oppose the premature release of the prisoner on untenable and hypothetical ground or apprehension. And next page, Miller, 4B. In case the superintendent of police is not in favor of the premature release of the prisoner, he shall justify the same with the cogent reasons and materials and shall send the reference keeping in view of the general or special guidelines laid down by the state government to the concerned district magistrate and the superintendent of jail with a period not later than 30 days from the date of receipt. And on receipt of the reference police, while concerned district, that is not relevant. And 5B, Millard, all this is also not mechanically and recommend each and every case premature release. And then the role of district magistrate 5C. Kindly see Millard, para 7, page 7, Millard. However, the Superintendent of Police Raurkela has not followed the guidelines for a premature release to the 22 by not giving cogent reasons and satisfactory materials which are showing that there is an apprehension of danger over the complainant and his family members by the petitioner convict. The SP Raurkela made a final report without any further inquiry on the report which was presented by the IAC Raghunathpalli PS and sent to the DM Superintendent. Para 7. That is humbly submitted that the complainant then was the bank manager at the time of the incident. The complainant is must to be on superannuation who may not be residing since few years in the same place. The inquiry report of IAC Raghunathpalli is silent on it. So it is crystal clear that the IAC as well as the SP have not thoroughly checked up and inquired about the whereabouts of the informant of the original case. It is also incorrect fact that the complainant may not a local person and there is an next page apprehension of danger to the life. Hence, the report is disbelieved. Para 8. That in reply to the averments made in paragraph 8 of the counter affidavit is humbly submitted that the premature release of the co-convict, namely Gopal Mahakot, on 21st of November 2019 was issued as per the guidelines of the new law Department Resolution number 4817 dated 5/5/2010, and the premature release of the present petition was rejected on the basis of new guidelines of the Law Department Resolution number 4375 dated 9th of April 2020. However, if the co-convict arising out of the same case is released on premature release on basis of a particular set of guidelines, the premature release of the other convict of the same case should have also been considered under the same set of guidelines. The guidelines under which the co-convict Gopal Mohakad was released prematurely should have a prospective effect for consideration of the premature release of the present petitioner. The natural justice should prevail, and the next page authorities should have considered the case of the considered favorably. Para 9. That the law is well settled that well, it is a case where the conviction date has to be taken. Now, a recent judgment I have not gone to, I got a judgment I am referring. That is, the law is well settled that in case of Hitesh versus Bhavako, my associate there, Millard, is citing the two judgments. So let me finish this paragraph. That the law is well settled that in the case of Hitesh alias Bhavko Srinivaskar Dabhe versus State of Gujarat in writ petition number criminal 467/2022, decided on 24th of January 2023, in determining the entitlement of a convict for premature release, the policy of the state government on the date of conviction would have to be determining factor. Let me pause for a moment. There are two circular guidelines under annexure writ petition also I have filed 2010 guidelines and the subsequent guidelines 2020-22 which state is relied. Here, Millard, the Honorable Supreme Court has set a law that the entitlement of convict for premature release, the policy of state government on the date of conviction of the state government, conviction would have to be determined factor. However, if the policy which was prevalent on the date of conviction is subsequently liberalized to prove more beneficial terms, those should also be borne in mind. Therefore, the petitioner's case may be considered in terms of the policy T/3 dated 5/5/2010 by resolution number 4817, which was in force at the time of conviction, as the conviction was recorded on 19th of July 2004 by the London Additional Session Judge Routledge. Therefore, the petitioner's case may be allowed on the above reasoning and supported by Honorable Appellate Court. Next page, page 10, para 10. That the law is well settled that the executive power, which is inherently discretionary in nature, has to be exercised fairly, reasonably, and not arbitrarily, has been held by Honorable Apex Court in numerous cases. Absence to do so would like to this case for other executive action, compel the court to exercise its judicial review and in appropriate cases remit the matter for reconsideration. The procedure laid down in section 432(2) of CRPC, I have wrongly misread, has been held to be mandatory by a 5-judge bench of Honorable Supreme Court, Union of India versus State of Siran 2015, 14 SCR. The Honorable Apex Court was pleased to allow the writ petition and directed the remission board to consider the application with a direction to board that the remission board should endeavor to consider the application of the appellant at the earliest and render its decision preferably within 3 months. And the judgment Millard relied upon 2023 AR Supreme Court 4084 Rajo versus Rajwa alias Rajendra Mandal versus State of Bihar and others, decided on 25th of August 2023. Para 12, Millard page. That it is pertinent to mention here that the present petition is undertaking a noble work by imparting education to the other prisoners inside the jail. The present petitioner has been teaching to the other prisoners since last 10 years. He has successfully reformed several prisoners and guided towards the right path. The conduct of the prisoner shines as a bright light in the of the hope of redemption for many other incarcerated prisoners, which fact is mentioned under Annexure 4 at page 21. Then reply to the government's paragraph 9, 10, 11 of the counterpetition.
No. In paragraph number 6 of your rejoinder affidavit as page number 5,
My
you
lord.
said that the SP Raurkela has mechanically relied on the report of the IIC Raghunathpally police station.
My lord.
The Raghunathpally police station has given an adverse report against you.
My lord.
So that was taken into account by the SP.
My lord.
What order SP has passed?
My lord, kindly see counter.
Not done his own assessment, he has passed a mechanical order.
My lord, kindly see page 10 of counter affidavit. Page 10, 11.
Page 10.
My lord. Ten and 11, both, my lord, kindly see. The 10 is the SP's report and 11 is the IAC report. Exact identical.
That is the counter affidavit. Huh? Odu? एथरे बाहर कर दिया এটা রিজয়েন্ডার ফ্ল্যাগ মারো কাউন্টার ফ্ল্যাগ মারি দিই
I only draw page 11 for the IAC Raghunathpally what Millard has stated.
Page 11.
My lord, of the same counter affidavit annexure C by 3 as filed by state.
C by 3.
Again, page 11. It is addressed to Superintendent of Police, Routela. Reference memo number 5541, DCRB, dated 9th of November 2022, and memo number so-and-so dated 9th of November 2020. Subject, submission of 4-point report of the premature release proposal of the convict number 1112/A Tarkeswar Chaudhary, village Bangla Tola, Santa Colony, PS Raghunathpally, Routela, district Sundargarh, at present Superintendent Jail, Routela. Sir, with reference to the letter and subject cited above, I have the honor to report that I have inquired locally on the 4 points and ascertained the following.
Yes, proceed.
My lord. Sir, with reference to the letter and subject cited above, I have the honor to report I have inquired locally on 4 points and ascertained the following. 1. Law and order problems cannot be ruled out, if Tarkeswar Chaudhary released on premature. 2. It is also written handwriting. Kindly also mark. On inquiry in locally, there is apprehension of keeping personal grudge over the complainant and family members by convict. 3. The convict may not lead a honest life for nil. Hence, the premature release proposal convict number 1112A Tarkeswar Chaudhary may not be considered. And my previous page 10 also. The same.
Just a minute. This rejoinder affidavit which he has filed in page number 5, what he has highlighted that the superintendent of police shall cause an inquiry to be made in the matter through a senior police officer of the appropriate rank. So that you have done, and the matter was entrusted to the inspector in charge of Raghunathpally police station. Now he has submitted this particular report, but it further says that you should not act mechanically getting such report. You must base on his own assessment shall make the recommendation. So no, it is just blindly he has quoted what the IAC has done, and just given the recommendation that requested that the premature release proposal of so and so may not be considered. So where is your application of mind? Where is your assessment? Because ultimately you may agree, you may not disagree, but uh, if you just quote what the IIC has stated, on the one hand, you are not providing any opportunity, not giving this copy of this inquiry report to the concerned convict to have his say. On the other hand, you are also not making your own assessment, but just relying on what the IIC has stated. You have made the uh, observation that don't um, it cannot be considered. So how this order is sustainable, which has been passed by the SP in rejecting? The only differentiation between the person who was prematurely released, same case, same offense, conviction, same sentence imposed by the London trial court, both filed criminal appeals. The appeals were dismissed, sentence, conviction and sentence were confirmed. And the same period they remained. Then while releasing one prematurely, the other application was rejected only on this ground that the IIC.
He was released prior to the this application was rejected, my lord.
Yes.
My lord, kindly come to para or counter affidavit. Paragraph 8, my lord. The co-accused Gopal was released on 21 November 2019, my lord. And this present petition application was rejected in 2022, my lord. And at the time of rejection of the 22, my lord, the new guidelines are in force, my lord. So prior to that, another, my lord, that regarding the eligibility, my lord, criteria, my lord, that is of 25 years, my lord.
No. So when you considered the case of one convict at that point of time,
my lord.
So same case, why you did not consider the case of this one?
My lord.
You consider the case of, you cannot say, you are right that he was released prematurely on 21/11/2019,
My lord.
and the petitioner case was considered in 2022,
My lord.
and that was rejected. And by that time, the guideline has come that unless 25 years he won his remand, in case of such offense, his case cannot be considered.
My lord.
That you are right, but question is that why when you considered one case on
at the time, my lord, so far the Gopal is concerned, my lord, the report of the police and the SP are not negative in that part, my lord. It was not negative so far the present petition is concerned, my lord. So he was released, my lord. But so far the present petitioner is concerned, my lord, there is a negative report of the SP and the IS, my lord.
At that point of time, in 2019.
At that point of time and also in this point of time.
So where is that aberment? That at that point of time,
that they have not challenged that's why we have not given any counter to that. Because they have not challenged the previous release rejection orders. They have only challenged the present release order that rejected order on 13/1/2023.
I see. Let us see their prayer.
Was the order dated?
Yes, 2/2/20.
23 annexed to.
Yes, Mr. Mishra.
My lord.
You are not challenging any previous order. You are challenging an order dated 2/2023. By that 2022 guideline has come, which indicates that 25 years must imprisonment should be there. Then what wrong they have committed if they have taken into account the second one?
Second one.
Previously, that is not under challenge before us. In 2019, one was released and your case was not considered or negative. That at that point of time you did not come. You remained silent. You are approaching this court challenging an order dated 22/2023.
My lord.
was passed basing on that the new guideline that has come in 2022, and apart from that the adverse report. So obviously, when they are considering passing the order uh, dated 22 to 2023, they are supposed to take the guideline which was existence at that point of time, not that the guideline which has already lapsed and it has been superseded by some other guideline. So it cannot be said that they have committed any wrong in considering the guideline of 2022.
Yes, admittedly, I have prayed for passing of the recent guideline.
Your case
And
was not considered in 2019 or rejected. Not know what has happened because since you have not challenged it, they have not filed their counter to that effect.
Yes, my lord.
You are only challenging the order dated to 2023. Now, your case can only be considered when that 25 years will be over.
My lord, now
It also seems from the pleadings when the repetition that it has not been disclosed that while considering the case of Gopal Gowda co-accused for premature of release on 2019, your case was negative. Rather, on such disclosure in para 8 of the counter in the rejoinder, you have stated so.
That was not brought to the notice. Yes,
my lord, as per the custody certificate, in the year 2022, I already completed 22 years, my lord.
22 years.
22 years.
Now it says how many years?
22 years. Now it is another 2 years.
Another 2 years, 24.
I think 2022 ରେ
Divas-
22 ବର୍ଷ.
2 ବର୍ଷ 22 ବର୍ଷ.
But the news clippings which have been enclosed to the repetition discloses that jail re शिक्षार आलोक देखुଛନ୍ତି तारे केशवर they have praised
News printing, my lord.
No, my lord. That is all, my lord. Right. That the jail superintendent, my lord, should have given, as per the my lord circular, the jail superintendent should have informed a detailed report of conduct. That is missing in this case.
A vital information from this court while filing that your earlier one was rejected and that was also not challenged. You are challenging the second one. So you are to wait till you complete that 24 years. Where is that 24 years?
25 my lord.
Huh?
25 ବର୍ଷ.
My lord, I humbly submit. I have not challenged. Pardon to lordship 2019 circular, my lord, I was not. But my point of my lord argument.
କାହିଁ ସେଟା ଦେଖେଇଲେ ସେଟା ଯୋଉ 24
When the present circular, my lord, doesn't apply in view of the Honorable Supreme Court judgment. I will humbly. That is a law I am advancing. If you lordship appreciate, the Honorable Supreme Court has, my lord, recently observed that the
Our count 28, my lord.
Under 25, they have stated 25 years.
It's 49.
49.
49.
Provided that the categories of life mentioned in clause A to E may be placed for consideration for premature release after commission.
କୋଉଟା ପଢୁଛନ୍ତି? Page?
Sir, 7 ra 7 6 ra proviso. Je proviso 6 proviso. The counter internal page 27 6 ରୁ start ହଉଛି.
In imprisonment for life or murder.
Yes.
Murder and rape. ଆଉ ସେ ଯୋଉ ଡକାଇତି with murder କାହିଁ?
A ରେ ଅଛି. A ରେ 6A.
6A ରେ. ಡಕಾಯಿತಿ with murder, right?
Yes.
And also murder of the public servant. Here also public servant has been murdered, my lord.
Murder of public servant kahin?
Say the last line. A or last line.
Murder of a public
on duty. So this case comes within these two categories.
My lord.
That is a proviso. The exception. Yes.
But
We humbly bow down. Even if this point, I am not causing the point, but other 2 points which have
the you are to take into account the policy which was existence at the time of conviction.
My lord, bow down.
There was any policy at all in existence at the time of conviction. Otherwise, the Supreme Court decision will not be applicable.
That is Annexure D/3. They have relied on the counter affidavit. Kindly see. Page 12 of internal page 12 of the counter affidavit starts that resolution.
So
Your Lordship, kindly appreciate. 2010.
Conviction. You are convicted in 2004.
Four.
So that
if 2004, then subsequent guideline came 2020-22.
Mr. Mishra, the decision says that if any guideline is there on the date of conviction, that is to be applied. And if any subsequent guideline comes in which more reliefs have been granted, that can also be taken into account. But you are found guilty in 2004. And 2004, there is no such.
Right. So that is available.
You are to give in and prematurely released.
Yes. 2004, there is no. I have.
There is no government. Nothing is there.
Yes.
So that Supreme Court decision which you are relying, that it is to be taken into, that is that cannot be.
However, if the policy which was prevalent on the date of conviction is subsequently revised to prove the judgment, I am filing my associate file 2020-23.
Come to that. There is some guidelines in the 2004 also, my lord. I'll come to the
2004.
Come to the page 12, annexure D/3. That new 2010, my lord. There they have mentioned it, to make uniform standard.
D/3,
my lord. To make uniform standard and criteria for determining the eligibility of prisoners undergoing life sentence for their premature release with other states of India, and as per guidelines furnished by the National Human Rights Commission in their letter dated 6/11/1999, state government by resolution dated so and so number and 26/9/2000 have constituted the state sentence review board with a view to review the of sentence awarded to a prisoner and for recommending his premature release in appropriate cases. Pursuant to the modification of para 3 and 4 of the guidelines issued by the NHSC in their letter dated 26/9/2003, paragraph 3 and 4 of the government resolution dated so and so dated 26/9/2000 was modified and to the resolution dated.
So this 2005 is subsequent to that. But it seems that there was some kind of the state government by resolution number constituted with a view. So what is that resolution?
I have to go to that.
Consolidated as
consolidated ସେତେବେଳେ କଣ କରା ତାକୁ ଏଇଗୁଡାକ applicable.
ଯଦି ସେଟାକୁ as per the Supreme Court ଆଣିଯିବା ସେଟାକୁ applicable.
ବେଟର ହେଲା ଠିକ ଅଛି ସେ ଦେଖିବାକୁ ପଡିବ ନା ସେଟା 2000 ଟା କଣ ହେଲା 2005 ରେ କଣ ଆସିଲା ତାପରେ ଏଇଟା ହଉଛି 2010 ଷ୍ଟେଟ ଗଭର୍ଣ୍ଣମେଣ୍ଟ has been pleased to answer state government shall be permanent body ଏଟା ପରେ ଆସିଲା
ତାପରେ ଆସିଲା.
So Mr. Mishra, have you got any copy of these two resolutions?
That I will have 2 minutes, sir. If I request my senior Mr. Das may.
Decision which has been cited by you.
My lord.
It's that if on the date of conviction, if any guideline is available, that is to be taken into account, and subsequently, if any relief comes, that can also be taken into account. So, from annexure D/3, we find that there is a resolution of 2000, and then
that is why some light. But I may request.
Then this 2010 came. So, if suppose for release of this a convict who has been sentenced to life imprisonment for dacoity with murder, the 2000 scheme is more liberal.
My lord.
The present one, then that can be also taken into account. So for that, or we can ask the state government also.
I'll be obliged. Yes, let the state produce that resolution.
But for that, we have to know that what was that actually resolution.
Yes.
Produce this
Yes.
both the resolutions. Okay.
Mr. Mishra has not gone through this.
On
that
yes, obliged. I am grateful to my senior, but I intend to develop my argument only 2 points when I
decision
on application.
in determining the conviction, the policy of the standing on the date of conviction, later also. How the policy which was relevant on the date of conviction is subsequently liberalized, that should also be borne in mind. It has a recent the live law. Huh. Some subsequent corrects. Also be borne. The date of conviction টা কেতে ହେଇଛି?
Again, 2004 just a minute.
2004, that is, my lord, 17/7 17/7
17/7
17/7
2004
my lord.
ଲେଖନ୍ତୁ ସେଇଟା ଆଉ 2010 ତ ଅଛି ଆଉ 2010 ଅଛି 22 ଅଛି ଟୋଟାଲ ଜାରି କରୁଛି ଟୋଟାଲ 4ଟା ଗାଇଡଲାଇନ ବା all right take down hard Mr. Mishra learned counsel for the petitioner and Mr. Das learned counsel for the additional government advocate for the state. During course of argument, Mr. Mishra cited the placed reliance on 2 decisions of the honorable. This other decision is also same.
No, not same, but the state advisory authority and the application of mine and the what of the to follow the as per provision 432 and 433. Supreme Court has observed certain things, had authority to act.
Placed reliance on the decision of the honorable reported in 2023 live law bracket race C72 in case of Hitesh alias Babko Shivshankar Dave versus State of Gujarat reported in Swanson, wherein it is stated that in determining the entitlement of a convict for premature release, the policy of the state government on the date of conviction would have to be the determinative factor. However, if the policy which was prevalent on the date of conviction is subsequently liberalized to provide more beneficial terms, those should also be borne in mind. In the present case, the petitioner was found guilty by the London Trial Court on 17/7/2004. It appears from Annexure DY3 annexed to the counter affidavit filed by the state that the state government by resolution number 12019 dated 26/9/2000 constituted the state sentence review board with a view to review the sentence awarded to a prisoner and for recommending his premature release in appropriate cases. Subsequently, pursuant to the modification of paragraph number 3 and 4 of the guideline issued by NHRC in their later dated 26/9/2003. Paragraph number 3 and 4 of the Government Resolution number 12019 dated 26/9/2000 was modified by Government Resolution number 7496 dated 25/5/2005. In view of the ratio laid down by the Honorable Supreme Court in case of Hitesh versus Hitesh alias Babko Shiv Shankar Dabe, bracket Supra, we feel it proper to peruse the State Government Resolution number 12019 dated 26/9/2000. So also the resolution number 7496 dated 25/5/2005. Stop. The Learning Council for the state seeks some time to produce those two resolutions on the next date. Accordingly, the date is fixed to 5 तारीख रखुछु put up this matter on 5th of February 2024.
Millard, with kind permission, Millard. Another aspect, Millard, I like to, because since the authorities has to act, Millard, bona fidely and with application.
On the next date, we are not deciding you finally.
Published.
Documents come and we'll pass.
And out that the report from the jail is important as per the even circular. The jail superintendent has not given that review. That aspect, Millard, that is also paramount consideration for Millard liberal view. The report of jail superintendent.
Report about the conduct of the petitioner from the jail, concerned jail superintendent, be also produced on the next date. No?
Great, Millard. Obliged. Highly obliged, Millard.
Item 7.
Of the petitioner is kidnapped by UP number 4 on 19/7/2023, and the petitioner has submitted the FIR, but the police has not any steps for which the petitioner moved before this honorable court, and this honorable court on 3/10/2000 on 3/10/2005 3/10/23 direct the government to
you told that you will highlight some development by
development means the OP number 5 on 7/1/2024 said that your daughter is no more. Your daughter is no more, you will not get your daughter. Therefore, I have
whatever it be with you are supposed to file the affidavit.
Yes.
So you are to give a copy also to this.
I have already given copy. Now they have given the affidavit on 19/1/2024 that he said that he has allowed some time.
They have made some allegations.
The victim guard.
9/1/2024 is your affidavit, right? 9/1/2024 affidavit ଆପଣଙ୍କର, in which you have stated in paragraph number 2 that the opposite party number 3 investigating officer so and so filed a statement before this court that she has investigated, sourced in many times, which is not correct. After direction of this court, the IO first gone to the so and so house by taking a car from the petitioner. The investigating officer directed to the petitioner that he will provide a vehicle, then they will go and search the petitioner daughter. Lastly, without getting anyway, the petitioner given a car to the police on so and so, and the police has taken to the petitioner and not inquired properly, but as indicated, some false statements so on. So this allegation has been made. So what is your?
I filed.
They have admitted in their counter in page 2, last para, that the deponent, after discussion with the IIC, accept the proposal of the petitioner.
What is the reason?
Them with their vehicle with the other staff along with the petitioner and his wife to.
What is the reason?
Contaminate to rescue the victim girl on 7/10/2023. But in the
report, on your request, we went.
All right. So that's a secondary matter. What has happened now?
Till that, my lord, we are taking also step. Not has been rescued, my lord. So more time also required, my lord.
All right. As for the order dated, as for the order dated 8/1/2024, the the Land Council for the petitioner has filed an affidavit and of the petitioner, no? And copy of the same has been served on the Land and Council for the state. On receipt of the same, this madam is Sasmita Parida. Sasmita Parida, Sub-Inspector of Police, Narsingpur Police Station, has filed an affidavit in which he has explained the allegation leveled against her. She also appears through virtual mode. The Land and Council, the affidavit filed by the opposite party number 3, the investigating officer is taken on record. The Land Council for the state has also filed the status report of the IO dated 18/1/2024. A copy दे दीजिए, copy of which has been furnished to the Land Council for the petitioner. The Land Council for the petitioner, so also the investigating officer seek further time to trace out the victim. Here the FIR is against a known person that.
Yes, because open our phone.
And for arrest of the FIR named accused. Put up this matter in the week commencing from 19th February of 19th February 2024. एगुड़ा taken on record कर देवें detail है ना.
Item 8.
My lord, last occasion, lordship directed me to file rejoinder. Accordingly, I have already filed rejoinder and copy also served.
Yes.
My lord, your lordship, annexure 5. Page 26. That is the ground of rejection. That
what is the ground of rejection?
Due to young age, he has not lost his potential for committing further crime.
Who afford him?
My lord, may I pray, my lord? They have served a rejoinder in court office, my lord. I have not received the file.
Rejoinder is also not on record.
Yes, my lord.
My lord, on 18th we have served and filed.
Rejoinder lagi नहीं file. केबे rejoinder file कले?
3rd तारीख. This is the receipt, my lord. Also copy
18/1/2023.
Yes.
Oh, thank office lagi नहीं file एठी भी state रे court रे अच्छी. All right. You let it be attached to your files, also the court file. It will come next week. All right. The Land Council for the petitioner submitted that he has filed a rejoinder affidavit on 18/1/2024 and served a copy in AG office. The Land Council for the state submit that the said rejoinder has not been tagged to the file, and registry has also not put the rejoinder on record. Put up this matter in the week commencing from 29th of January 2024. Registry shall place the rejoinder affidavit on record. Yes.
Item 9.
Well, item 9 types of 19.2 को जाइतला. So wrongly typed as 19.1, my lord. 19/2 କୁ ଯାଇଥିଲା 19 ଫ୍ରାଇଡେ କୁ
10/1 ତ ଥିଲା।
10 ଏପ୍ରିଲ 19/2 କୁ ଯାଇଥିଲା।
ସେଟା ଟାଇପ ହେଇଯାଇଛି ରଙ୍ଗରେ।
ହଁ 19/1 ହେଇଯାଇଛି।
ଆଚ୍ଛା।
19/1 ତ
Yes, Mr. Pandey, what do you say? Let it come on 19th to.
let's say
No,
only aim and intention
ଆପଣ ଥିଲେ ସେଦିନ କୋର୍ଟରେ ମୁଁ ଜାଣିନି କହୁଛନ୍ତି ଯେ ତାଙ୍କ ରେକର୍ଡରେ ମେନସନ ହେଇଛି 19/2 ବୋଲି।
ହେଇଥିବ ମ୍ୟାଡାମ।
Alright, ଲେଖନ୍ତୁ
but my lord ତାଙ୍କର only aim and object 18 ବର୍ଷ ହେଇଗଲା ପରେ ବାହାଘର କରିଦେବେ ଆଣିବେ।
The learned counsel for the
Entire
state submitted that
filing
the
of the
case was
petition
adjourned to
substituted balance.
19th February 2024, but inadvertently in the order dated 10/1/2024, on 10/1/2024, it was adjourned to 19th February, but inadvertently in the said order, the date has been mentioned to be 19th January 2024, and that is how it has been listed today. And the matter will be listed in the week commencing from 19th February 2024. The learned counsel for the petitioner has no serious objection to the same. Put up this matter in the week commencing from 19th February 2024. Yes.
Item 2 done. My lord, out item ରହିଛି parted ହେଇକି item my lord, that is item 16 my lord.
Counsel is present.
So can we take tomorrow?
It can be taken up tomorrow.
Pass over item number 2.
May it please your lordship. Your lordship, the present appellant has been convicted by order dated 3/7/2010, your lordship, passed by the ad hoc additional sessions judge, FTC 2 Balesur, for an extreme the appellant has been sentenced to undergo RI for life and
No, petitioner is a
appellant.
lady.
Yes, your lordship.
So 302 life imprisonment.
Yes, your lordship.
Okay, please come to the charge. Let us see that what is the charge, and then you go to the FIR and then place your case.
Yes.
So charge is at page 30.
31.
Okay, please place the charge.
I so and so hereby charge you, Gitanjali Pradhan, the present appellant, as follows. Firstly, that you on or about 5/4/2007 at about 7 a.m. at Puttina did commit murder by intentionally causing the death of one Pooja Pradhan and thereby committed an offence punishable under section 302 IPC and within my cognizance.
How the deceased was related to the appellant?
Yes, your lordship. The deceased is the son of daughter of brother-in-law of the appellant, your lordship. The deceased
କେତେ ବଡ ଜିନିଷ କହିଲେ କି ମୁଁ? Deceased is the
niece of the appellant.
ଝିଆରୀ ହବ
ଆଜ୍ଞା
ମାନେ ଭାଇର ଝିଅ?
ନାଇଁ ଆଜ୍ଞା, ମାନେ ଦେଢଶୁରର ଝିଅ ହବ।
ଦେଢଶୁରର ଝିଅ?
ଆଜ୍ଞା।
What was the age of the deceased at that?
25 days.
25 दिन?
ଆଜ୍ଞା।
So why is he accusation that why she killed her?
Your lordship, there is no motive as such, your lordship.
ଦେଢଶୁରର 25 ଦିନର ଛୁଆକୁ ମାରିଛନ୍ତି ବୋଲି ଆପଣଙ୍କ ନାଁରେ ଅଭିଯୋଗ?
ଆଜ୍ଞା।
All right, you come to the FIR, let us see.
FIR is at page 27.
Okay, please place it.
Yes, Your Lordship. महाशय आमे श्री शंकर प्रधान बयस सोइंस मु आजी गुरुवार तारीख 5/4/2007 तारीख दिबा 12:15 रे कमरदा थाना रे उपस्थित होई
शंकर प्रधान होची एतलाकारी
PW3
he is PW3.
Yes, Your Lordship.
Okay. हाँ
ଉପସ୍ଥିତ ହୋଇ ଏ ଲିଖିତ ରିପୋର୍ଟ ଦେଉଛି ଯେ ଆଜି ସକାଳେ ମୁଁ ବିଲକୁ ଯାଇ ଦିନ 8ଟା ସୁଦ୍ଧା ଘରକୁ ଫେରିଲି। ମୋର ଭାଉଜ ସ୍ୱର୍ଣ୍ଣଲତା ପ୍ରଧାନ ମଦର ଅଫ ଦ ଡିସିଜ୍ଡ Your Lordship, ସ୍ୱାମୀ
ते एग्जामिन ହେଇଛି
ଆଜ୍ଞା
କେତେ नंबर साकी
PW5 my lord.
PW5 ସ୍ୱାମୀ କାହ୍ନୁଚରଣ ପ୍ରଧାନ ଠାରୁ ଶୁଣିଲି ଯେ ଆଜି ସକାଳ 7ଟା ସମୟରେ ମୋର ଭାଉଜ ତାର ଛୋଟ ଝିଅ ପୂଜା 25 ଦିନକୁ ତାଙ୍କ ଘର ବାରଣ୍ଡାରେ ଦୋଳିରେ ଶୁଆଇ ଦେଇ ବାସନ ମାଜିବାକୁ ପୋଖରୀକୁ ଯାଇଥିଲା। ପୋଖରୀରୁ ଫେରି ଦେଖିଲା ଯେ ତାର ଛୋଟ ଝିଅଟି ଦୋଳି ଭିତରେ ନାହିଁ। ତାପରେ ବଡ ଭାଉଜ ଆରତୀ ପ୍ରଧାନ ଖୋଜାଖୋଜି କରି ଗୀତାଞ୍ଜଳି ପ୍ରଧାନ
आरती प्रधान किए
ଆରତୀ ପ୍ରଧାନ has been
PW6
Your
lordship.
Lordship.
PW6 हाँ
Yes. आरती प्रधान खोजाखोजी करी गीतांजलि प्रधान द प्रेजेंट appellant Your Lordship.
appellant
स्वामी लंबोदर प्रधान को घरु मोर जियारी पूजा को मूसा माटी भितरु मला अवस्थारे पाइले ओ देखिले जे झियटीर तंटी कटा हेछि। आरती भाउज गीतांजलि प्रधान को पचारिबारु से पूजार बेककु दारे काटी मारी देइथिबार स्वीकार करिबारु उक्त समय रे मु मोर ककार झियो भौणी ज्योत्स्ना राणी गिरी ओ कविता प्रधान माने सुनिचंती।
ज्योत्स्ना रानी गिरी is PW
Your Lordship. Your Lordship, she has not been
She has not been
examined.
not been examined Kavita
Not, no, Your Lordship.
not been examined. So the allegation is that the deceased was aged about 25 days, right?
Yes.
At the time of occurrence, and her mother is PW5, and that child was in the cradle, and the mother has gone to
Wash utensils.
backyard to acha, for washing the utensils. Okay, at that point of time when she returned back, the child was not there, and then search was made, and okay, from your house
Yes.
and from the hole of that rat, it was found, the dead body was found, and it was found that
Neck was
there was a cut in the neck portion. Okay, then you made extrajudicial confession before the PW5 Arati Bhaujo Gitanjali Pradhan ko pacharibar, and at that point of time, two other persons were present, but
they have not been examined.
okay, so it's a case based on circumstantial evidence.
Circumstantial.
So one, as such, we find that it is extrajudicial confession.
Yes, Your Lordship.
That is before PW5.
PW5.
Any other witness has just stated about that extrajudicial confession?
Yes, Your Lordship.
Yeah.
Your Lordship, PW9 and PW6.
PW6 PW5 ता माँ से छुआर माँ
Again.
PW6 किए
Lordship, PW6 is आरती प्रधान the ଆଉ ଜଣେ ଯା ତାଙ୍କର ଯାହାକୁ
अच्छा
ନେଇକି ପଚାରି
and PW9
He confessed before Arati.
Yes, Your
नहीं सी आप अगर ये भी थिला ये ताकू थिला दियन जब पूजा करी Arati was जितना प्रथम पचारू से but she was also present. Man, this PW5 was also present. PW5 6 and they said PW9.
Yes.
Okay, that is one part of the one evidence against you, that is extrajudicial confession. Then what else is there against
Your Lordship, the blood stain from my clothing, the blood stain I gave
you? Recovery of that dead body from
my
your house,
residence, from
right?
my
So
house,
that is the second
from
one.
my room.
Just a minute. recovery of the dead body from the house of appellant. Okay, number 2. Next.
Blood stains from my bedroom again.
Okay. Blood stain from the bedroom of appellant. Yes, next.
Your Lordship, this is the.
These are the 3.
These are the 3.
So you were taken into custody since when?
Your Lordship, 5/4/2007.
5/4/2007.
Yes, Your Lordship.
You are not on bail during trial.
No, Your Lordship.
And this court also has not granted you bail. That means you have already undergone more than 16 years and 8 to 9 months of sentence. Okay. So if that is the, let us then go to the that extrajudicial confession part PW5.
Yes, Your Lordship.
Okay.
Page 47, Your Lordship.
And who is the doctor who has conducted PM examination?
PW10, my lord.
PW10.
PW10. So what opinion he has given?
Lordship, opinion is that of.
What is the cause of death? That cut off.
Cut.
That
Yes.
no neck.
Yes, Your
Say that it is possible.
Yes, possible.
What is that weapon?
Sickle, your lord.
Sickle. Acha, dar kati di. Sickle seized from the spot, sent to doctor. Positive opinion.
Yes.
Okay.
All right. You come to PW5, the mother of that deceased.
Page 47, Your Lordship, of the paper book. I know Shankar Pradhan of our village. I also know accused Gitanjali Pradhan.
No, the names which you are reading, if they have been examined, just indicate the PW.
Yes, Your Lordship. Shankar Pradhan is PW3, Your Lordship. The informant. Your Lordship. I know Shankar Pradhan of our village, PW3, Your Lordship. I also know the accused Gitanjali Pradhan, appellant. Pooja is my daughter. She is dead. She died in the month of Chaitra last year. My deceased daughter was aged about 25 days at the time of her death. Gitanjali cut the throat of my daughter Pooja. As a result, she died. Gitanjali cut her throat by means of a sickle. Just before the incident, my daughter slept on our veranda in a dori. I was engaged in my household work. I had seen her sleeping and I went to a tank situated in our body. When I came back home, accused Gitanjali came to our house just following me. She came and asked me for tobacco. I gave her tobacco. I was inside my house when accused went to her house, taking tobacco from me. Gitanjali is the daughter-in-law of my uncle-in-law. Sometime after my nephew Umakanta Pradhan came to our house. When I came out of my house to serve him food, I found my daughter.
Umakant is PW? Is examined or
PW9.
9
PW9.
Yes.
Or before whom that
Yes,
extrajudicial
Lordship.
confession. All right.
It was about 7:30 a.m. or 8 a.m. Gitanjali was sitting in her veranda adjacent to our house. I inquired the matter from him, but she denied her knowledge. I also inquired from others, but they were unable to answer. I called my Bodoja, Arati Pradhan. Arati Pradhan is PW6, Your Lordship.
PW6?
Yes, Your Lordship.
Yeah.
And disclosed this fact to her. My Bodoja also searched for the child. On query, she suspected Gitanjali. Again, on query, accused Gitanjali went inside her house and showed the child to me and my elder Ja. We saw the child was kept inside a mouse hole. We saw the throat of the baby was cut. Her entire neck was cut, leaving a portion. The room from which the baby was brought was the bedroom of accused Gitanjali. Your Lordship. I have also seen bloodstain mark inside the said room. I have also seen bloodstain mark on the wearing sari of Gitanjali. I have also seen the sickle in the said house, which was shown by accused to us. The sickle was stained with blood. My elder Ja Arati inquired from the accused to know the cause of the incident. Accused Gitanjali disclosed that she cut the throat of the baby as she had been quarreling the mother of the deceased. Accused Gitanjali disclosed she cut the throat of the baby as she had quarreling the mother of the deceased. She had a quarrel with the present
this witness.
Yes,
Okay.
Your Lordship. I was examined by the police. Then the cross examination. The informant is the younger cousin brother of my husband. My husband has got 4 other brothers. My husband and 2 other brothers were staying jointly. Then on further cross examination, in our family, there are 6 adult persons and 4 children. There are 2 bedrooms in my house. There is 1 veranda. There is no veranda in our house. Atul Pradhan, Narasingha Pradhan's house are near my house. I cannot say the situation of house of Madan Rao. There is no fence around my house. The house of accused and my house is situated having gap of 1 cubit in between. I have good neighborly relationship with Atul and Narasingha, so also with the family of the accused. Your Lordship. The tank is about 200 meters from my house. There is road in front of my house. People use that road. I came to house from the tank within 15 to 20 minutes. I inquired from my neighbors. Gitanjali had 2 daughters and 1 son. I cannot say what was the age of her son. On the date of incident, when I inquired about missing of my daughter from Doli, she was having her son in the lap. Your Lordship may notice. Para 8, Your Lordship. When my Bodoja went inside the house of accused to search for my daughter, I did not accompany her, Your Lordship. This is a contradiction, Your Lordship. By the time the accused admitted to have cut the throat of my daughter, I was present and many other persons, about more than 50 were present. Your Lordship may note this. I cannot say whether the accused was in a tying condition, Your Lordship. I do not remember the color of the sari the accused has put on the date of the incident. I cannot say if the statement of Gitanjali regarding murder of my daughter was reduced into writing. It is not a fact that accused did not admit to have murdered my daughter before me, nor the dead body of my daughter was recovered from her bedroom. Lordship may look into para 8 of the cross examination of the said witness. Lordship, para 8 of the cross examination, in the chief she says that she had accompanied to see the dead body, Your Lordship. But in para 8 she has denied the same. And also,
the overall circumstances, number 1, the recovery of the dead body from your house.
Yes.
And that was from inside a rat hole or mouse hole.
Yes.
Number 2, about the homicidal death, that the throat was cut, almost cut. Then number 3, that weapon was lying in that room. It was a sickle having bloodstain, and there was bloodstain on your sari.
Yes.
And number 4 is the extrajudicial confession you made before these witnesses, as you said.
Yes.
Number 5 is that when the postmortem was conducted, it was found to be a case of homicide and the neck was cut and that particular weapon was sent to the PM doctor and he examined it and opined that the baby's throat would have been caught by this particular weapon.
Yes, yes.
And sickle was also, as I find, that the sickle was sent for chemical examination and human blood was found. That is at page 78, the C report is there.
Yes, that has not been group, but human blood has been found.
So, how do you explain a child's dead body having a throat cut that was found inside your bedroom, inside the mouse hole? 25 ଦିନର ଛୁଆଟା ମୂଷା ଗାତ ଭିତରେ ତାର ବେକ କଟା ହେଇଛି, ତାକୁ ତା ଭିତରେ ପୁରା ହେଇଛି ଏବଂ ସିକିଲ ସେଇଠି ପଡିଛି, ରକ୍ତ ପଡିଛି ଆପଣଙ୍କର ବେଡରୁମରେ, ଆପଣଙ୍କର ଶାଢୀରେ ବ୍ଲଡ ଷ୍ଟେନ୍ ରହିଛି ଏବଂ ଆପଣଙ୍କର କନଫେସନ ରହୁଛି ଯେ ଯେହେତୁ ସେ ଛୁଆର ମା ଅର୍ଥାତ୍ PW5 ସାଙ୍ଗରେ ମୋ ସାଙ୍ଗରେ ଝଗଡା କରୁଥିଲା, ମୁଁ ସେ ଛୁଆଟାର ବେକ କାଟି ଦେଇଛି, କାଟି ଦେଇନି ମୂଷାଗାତ ଭିତରେ ପୁରେଇଛି, ଏଇଆ ହଉଛି କେସ୍. How do you explain it?
Your Lordship, I have taken recourse to section 84 of IPC, Your Lordship. I was suffering from schizophrenia. I was suffering from schizophrenia, Your Lordship. I had lost, I was impaired with my judgmental facilities, Your
How
Lordship.
do you say so? Because you have, as it appears, you have two daughters and one son.
Yes, Your Lordship.
And at that point of time, you are also holding one of your son in his lap.
In my lap.
And you are taking khoini from the other person, PW5.
Yes, Your Lordship.
Nobody has stated that you are behaving in an in any manner which would show that you are of unsoundness of mind.
Your Lordship.
Because what the law requires under 84 is the legal insanity.
Yes, Your Lordship.
Yes. So for that, for determining the same about your conduct prior to the occurrence, at the time of occurrence, if it is available, or after the occurrence, all those things have to be taken into account. Are you producing any kind of medical evidence?
Yes, Your Lordship.
What
That is
evidence you are producing?
defense witness number 1 and 2. Those are jail doctor, Your Lordship. Your Lordship, the appellant belongs to a very poor section of society. She has also engaged a state defense counsel, Your Lordship. There are prosecution witnesses who have said that I have a history of illness, Your Lordship. The prosecution witnesses, there is one prosecution witness who has said that I have a history of mental illness, Your Lordship. And two defense witnesses who are the jail doctors, Your Lordship, they have diagnosed me with schizophrenic depression and they have specifically stated that this is an old disease, Your Lordship. That is...
No, the relevant point of time is when the occurrence took place.
Yes, Your Lordship.
Mental ailment is of different kind.
Yes, Your Lordship.
Okay.
Yes, Your Lordship.
So question is that at that point of time, your state of mind was such that you are not able to know or judge what you are doing was legally wrong.
Yes, Your Lordship.
Okay. So 84 says that if you are in such a state of mind and burden of proof lies on you.
Yes, yes.
To prove that burden of lies on you. And merely some statement that तारो मानसिक अवस्था ठीक नथिला बा जेल रे बहुत डिप्रेशन अवस्था रे रहउथिला, जेल रे तो ऑब्वियसली आपण डिप्रेशन, आपण दीटा छुआ को छाडी कि नाइचंती, तीनटा छुआ जेल रे रहिचंती, एकुटिया रहिचंती, डिप्रेशन
That
हबो.
is what I am specifically placing, that this is not something that jail re rahila pare. The doctor has opined that mane eta continue aguru bi eta thilla boli. And also, Your Lordship, case based on circumstantial evidence, Your Lordship. Had my motive been to do away with the child or take revenge from do so.
मोटिव आपण जो कहउछन एब्सेंस ऑफ मोटिव, आपण के ए विटनेस एटलीस्ट किछि मोटिव दउछि ना. आपण जो एक्स्ट्रा जुडिशियल कन्फेशन रे आपण मोटिव विषय रे कहि दउछन निजे जे जेहेतु ता मा.
Your Lordship, that extrajudicial confession is not free from coercion, Your Lordship. There are other witnesses
who brought out that
yes, Your Lordship.
50 persons were there. That's a different matter. But the fact that in that very extrajudicial confession, you have giving the reasons why you see, nobody else was there.
No, Your Lordship, I agree.
How then the child's dead body would be found from your bedroom from the mouse hole, and your bloodstain sari and the weapon with which the offense has been committed, how those things would be found from that your bedroom? Who has kept and it killing the child in your bedroom in the mouse hole and accusing you falsely? Who would be there? Question is that the
Yes, Your
court
Lordship.
has to take all
Hmm.
these. So if it would have been some other place, matter is different. So all these things we have to see that whether the chain is complete or not.
Complete or not.
You right from the beginning you said that there is absence of motive, but as it appears that ତା ମା ସାଙ୍ଗରେ ଆର କଳି ଥିଲା, ଅର୍ଥାତ PW5 ସାଙ୍ଗରେ deceased ର କଳି ଥିଲା, ସେଇ କଳି ଯୋଗୁ exception
Your
କୁ
Lordship,
ନେଇକିନି
like that is what PW5 is saying, and
yes
on the same breath, she has also said that she is having good relationship with me,
no
with
no
my family. That is there, Your Lordship.
hmm
PW5, Your Lordship.
hmm
She said that in the extrajudicial confession ରେ ମୁଁ କହିଲି କି ମୋ ତାର ମା ସହିତ ଝଗଡା ହଉଥିଲା ବୋଲି ମୁଁ ପିଲାକୁ ମାରିଦେଲି.
hmm
I have ମାନେ ମୁଁ but in the cross examination that PW has only said I have good neighborly relationship with Atul and Narsinga, so also with the family of the accused, Your Lordship.
କୋଉ ଜାଗାରେ?
That is cross examination, page 49, para 6.
ହଁ ସେ ପରିବାର ସହିତ ହୁଏତ ଭଲ ସମ୍ପର୍କ ଥାଇପାରେ, କେହି କରିନଥାଏ, ଆପଣ ତ ରିଲେସନ ନା। କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ଯେ କଳି ହେଇଛି ତା ସାଙ୍ଗରେ ଏବଂ ସେଇଆକୁ ନେଇକିନି ମୌକା ମିଳିଛି, ଛୁଆଟା ଶୋଇଛି ଏକୁଟିଆ
Your Lordship,
ଦୋଳିରେ, ତାକୁ ନେଇକିନି ଏଇଟା କଣ, ହାଉ ଇଟ୍ କ୍ୟାନଟ୍ ବି ସେଡ୍ that it is totally mismatch
Your Lordship,
with each other.
another thing is they have brought out this enmity by the way of a extrajudicial confession, Your Lordship. Taro just occurrence ro just aguru, I have only asked for tobacco from that mother of the accused.
Huh.
So as such, I never had any enmity with that person, Your Lordship.
No, you are very calm, appears to be very calm mind. After committing the
Your Lordship,
crime,
that,
you are not expressing anything. You are asking tobacco. That shows
Your
that
Lordship,
you are
that
not
is
in
what
a
I'm contending.
mental ailment. Your mental condition was very good.
Your Lordship,
Even after
because I
committing
failed
the
witness.
child murder and keeping it in a secret manner hidden inside a rat hole, you are behaving like a normal man.
Your Lordship, had my intention be had more jodi thanta, I would have run away from that place.
Examination sheet that I have with the later. So she told, rather she saying that she told, being asked why you did so, she told that she had a quarrel with the mother, that's why she did that. But she's not saying that she had a quarrel. Who has stated? This witness, without the file, has stated in paragraph 4 that on being asked as to why she did so, she told this, but she is not saying she had a quarrel with me. She has not. That's what she might have committed. So that's not her statement. Further in the FIR also she has not stated so. FIR is not lost by this man. FIR is
No,
lost by
FIR has been lodged by another person.
somebody else, PW3. FIR extrajudicial confession ପାର୍ଟଟା ରହିଛି। ସ୍ୱର୍ଣ୍ଣଲତା ନଥିଲା, ଆରତୀ ଥିଲା, ଦେଖିଲା ସ୍ୱର୍ଣ୍ଣଲତା ଠାରୁ ନେଇଲି ଆଜି ସକାଳ ଶୁଣାଇଛୁ କଲି, ଘରୁ ଫେରିଲା, ଦେଖିଲା ଯେ ତାର ଛୋଟ ଛୁଆଟି ନାହିଁ। ତାପରେ ଭାଉଜ ଆରତୀ ପ୍ରଧାନ, ଗୀତାଞ୍ଜଳି ପ୍ରଧାନ ଘରୁ ମୋର ଝିଆରୀ ଶୁଣାଇଛୁ ମଲା ଅବସ୍ଥାରେ ପାଇଲେ ଓ ଦେଖିଲେ ତଣ୍ଟିଗଲା। ଆରତୀ ଭାଉଜ ଗୀତାଞ୍ଜଳି ପ୍ରଧାନ ପଚାରିବାରୁ ସେ ପୂଜାର ବ୍ୟାପକ ଶୁଣାଇଛୁ। ଆରତୀ ଭାଉଜ is PW6 will go through that evidence. ସ୍ୱର୍ଣ୍ଣଲତା ନଥିଲା, ନାଇଁ ସ୍ୱର୍ଣ୍ଣଲତା ନଥିଲା ବୋଲି କହୁନି, ଦେଖୁନାହାନ୍ତି ସ୍ୱର୍ଣ୍ଣଲତା ଆରତୀ ଭାଉଜ ଗଲେ ପଚାରିଲେ, ଆରତୀ ଭାଉଜ ଭିତରୁ ଯାଇ ଦେଖିଲେ ମୁଁ ତାଙ୍କ ସାଙ୍ଗରେ ଥିଲି ବୋଲି ଏଠି ମୁଁ କଣ ଇଏ ତ ଇଏ ନଥିଲା ଟୋଟାଲି। PW3 was not present. PW3 ର case ହଉଛି ଯେ ମୁଁ ଇଏ ଶୁଣିକି ନି report ଟା ଦେଇଛି ନା. So he said that this has happened like this, that when PW6 confronted the appellant told that I have committed this crime, and of course it is not there that at that point of time so and so was present, but it's what about the evidence of PW6?
Yes, Your Lordship. Your Lordship, PW6 is the first person to inquire from the appellant. I'll place page 51, Your Lordship. I know the accused. She is the daughter-in-law of my uncle-in-law. I knew the deceased. She was the daughter.
PW6 page hoji 51.
Yes.
Here.
Yes.
Yes. I know the accused. She is the daughter-in-law of my uncle-in-law. I knew the deceased. She was the daughter of Swarnalata Pradhan, PW5. On the date of incident, I went out to tend my cattle for grazing in the field. I returned to the house at about 7:30 or 8 a.m. and saw Swarnalata was crying. I inquired about the cause of her crying. She disclosed that her daughter was in the doli and she was working inside the house and her daughter was missing from the doli. So in a bid to search for the missing daughter of Swarnalata, I inquired from the sisters of my husband and others. Then I inquired from Gitanjali, who was in the doli of her house. Her house was close to our house. Then the accused went inside her bedroom. I followed her. She followed me a place inside her house where a kodai was kept. Underneath the kodai, some loose earth was found. Accused in her hand removed the loose earth, brought out the dead body of daughter of Swarnalata. I found neck of the child was cut. I inquired about the cutting of the neck of the child. Accused Gitanjali admitted to have cut the neck of the child by means of a sickle. Then she put the dead body on the cloth lying on the floor of the house. She was about to go away from the room, but the persons assembled outside and detained her. I made statement to police when come for investigation regarding the death of daughter of Swarnalata. Cross-examination. The family of Gitanjali consists of her in-laws and children. My family and family of Gitanjali were not unfriendly. There were many persons near our house by the time I returned from the field tending cattle, Your Lordship. Lordship, before she says there were already many persons who had assembled in the house. 4 to 5 times, I loudly asked Gitanjali about the daughter of Swarnalata. On the Duaro Pindo Dodi, the daughter of Swarnalata was kept. There is a road, Rasta, that was not used by the public. I accompanied Gitanjali alone inside her house. PW5 had not accompanied with her. I did not bring the dead body. Till the arrival of police, the dead body was in the house of Gitanjali. The police examined me on the date of incident. The time of my examination was 8:30 a.m. or 9 a.m. It is not a fact that I did not state to the police that accused Gitanjali showed me the quarry meant for storing paddy and she removed the loose earth as she brought out the dead body from inside the loose earth and she was about to go away. Lordship, next para is important. The persons present tied Gitanjali. I saw Gitanjali was sitting in a doli. When Gitanjali admitted to have cut the throat, the Swarnalata's daughter, other persons outside the room had seen her admitting the guilt, Your Lordship. I cannot give the number of persons present there. Gitanjali was not suffering from any disease, either physically or mentally. It is not a fact that Gitanjali did not admit to before me to have cut the throat of Swarnalata's daughter, and dead body of child was not recovered from the bedroom of Gitanjali, and I am deposing falsely, Your Lordship.
So what is your submission? Except this one line that I accompanied Gitanjali alone inside her house,
Your Lordship,
which according to you that she has not stated. PW5 was present when she went inside the house of Gitanjali, the appellant, and therefore the extrajudicial confession before PW5 is not acceptable. That is one part of your argument.
Yes, Your Lordship.
And the second part of your argument is that she was tied
Yes, Your Lordship.
Brought out and lose on the persons present at Gitanjali. But question is that when the extrajudicial confession was made, at that point of time she was not tired.
No, Your Lordship.
Lordship,
Your Lordship, that is
PW3 has stated that, Your Lordship, when at the exact point of time when she was tied. PW3 is also a witness
So
to the
question is that when the extrajudicial confession was made, whether there was any kind of threat,
yes, Your Lordship.
coercion,
Yes, Your Lordship.
or any kind of inducement to her, so that the extrajudicial confession will not be
Taken
relied
in-
upon in view of Section 24 of the Evidence Act.
Yes, Your Lordship.
But after making the extrajudicial confession, because the people were agitated and they were against you and they tied, that doesn't go, cannot be a ground to disbelieve that extrajudicial confession part. Had it been a case that after the persons tied Gitanjali, threatened or assaulted, then this extrajudicial confession was made, matter is different,
Yes,
right? But here is a case when extrajudicial confession was made prior to the persons tying the appellant. So how do you say that the extrajudicial confession, no reliance can be placed on extrajudicial confession?
Your Lordship, if Your Lordship comes to para 3 of the cross examination, Your Lordship, there itself
Of this particular
of this
witness?
particular witness,
Yes.
Your Lordship. There she says 4 to 5 times I loudly asked Gitanjali about the daughter of Swarnalata.
ଲାଉଡଲି ଆସ୍କ ଆଉ କଣ ତାକୁ କଣ ହେଇକିନି ପଚାରିବ ନା କଣ ହେଇଛି କହ କଣ ହେଇଛି କହ କୁଆଡେ ଗଲା କାହିଁ ଛୁଆ କେମିତି ତୋ ଘର ଭିତରୁ କେମିତି ଆସିଲା ତା ବେକ କେମିତି କଟା ହେଲା ଏଇ ବିଷୟରେ ତ ପଚାରିଛି ଆଉ କଣ ଆଉ ସେଇ ତାରି
Your Lordship, this has happened before she has given the discovery of the
see
child.
that is not the language of section 24. Language is something different though. Come to section 24. Confession caused by inducement, threat, or promise. These are the three things which are irrelevant. It is not a case of promise or it is not a case of inducement here. The only thing is that threat. Where is the evidence that she was threatened to make extrajudicial confession?
Your Lordship.
मानु जोशो मानछु ना तते मार देवी. This is the threat. कौन ହେଇଛି କହ କେମିତି ଛୁଆର ଡେଡ୍ ବଡି ତ ବେଡରୁମ ରୁ ମିଳିଲା କଣ ହେଲା ଛୁଆ କେମିତି ମଲା କହ ଏଇ ସବୁ ଜୋରରେ ପଚାରିବାଟା କଣ threat?
Your Lordship, my contention would be in para 5 again. She has said that the persons present tied Gitanjali. I saw Gitanjali was sitting in a dodi. When Gitanjali admitted to have cut the throat, other persons outside this room had seen her admitting the guilt, Your Lordship. That means a mob had already been acquired there, and that is
Mob, you have brought it out that the 50 persons came. They also tied. Question is that the evidence is that she alone. That evidence has come in your cross-examination. That she alone entered into the bedroom of the appellant. And at that point of that is your ground that the extrajudicial confession before PW5 should not be believed because PW5 has not accompanied PW6 and the appellant inside the house where the dead body was found. So the extrajudicial confession was made only to PW6, right? Thereafter, she was tied. So even if subsequently she has made any extrajudicial confession, that was in a condition where she was tied. So that may not be acted upon. But what about the first one which she made inside the bedroom to PW6?
Your Lordship, that is what has been confirmed by PW9 that when the PW6 has first asked the person, Your Lordship, she has not given any reply. Only after this mob has come, she has then replied.
Let us see that.
That is PW9, Your Lordship, page 58.
Please place the evidence of PW9.
Accused Gitanjali Pradhan is my agnetic aunt. The informant Shankar Pradhan is my agnetic uncle, PW3 Your Lordship. The incident took place on 5.
Shankar is PW3.
Yes, Your Lordship.
Okay.
The incident took place on 5/4/2000. On that day, at 8 a.m., I found Swarnalata Pradhan was searching for her
Swarnalata is PW5.
5, Your Lordship.
Right.
For a 25 days kid who was found missing from the dole. Thereafter, Swarnalata inquired from all the inmates of their house, including Gitanjali Pradhan. First, Gitanjali Pradhan was reluctant to give any reply. But when she was repeatedly asked, she confessed that she had murdered the deceased by cutting her throat by means.
You see, you are now claiming about the unsoundness of mind.
Yes.
Suppose she would have been uttering without being any मुंह से छुआ को मार देली मुंह से छुआ को मार देली चित्कार करथला ये होथला that would have been a ground that she was not in a state of unsoundness mind. ଆପଣଙ୍କୁ ପଚରା ହଉଛି ଛୁଆ କୁଆଡେ ଗଲା ଆପଣ ଚୁପ ରହୁଛନ୍ତି କିଛି କହୁନାହାନ୍ତି. Question is that why it is relevant to see the conduct of the ଜଣେ ଲୋକ ଯିଏ ଯାହାର ଅନସାଉଣ୍ଡନେସ୍ ଅଫ ମାଇଣ୍ଡ ଥିବ ସିଏ ଗୋଟେ କମିଟ କଲା ପରେ ଇଏ ତାର ଯୋଉ ଟାଇପ ର ରିଆକ୍ସନ ହବ that would show that at that point of time he was not in it. ଏଠି ମନେକର ଏଇଆ ହେଇଥାନ୍ତା ସେ ଚିତ୍କାର କରୁଥିଲା ମୁଁ ସେ ଛୁଆକୁ ମାରି ଦେଇଛି ମୁଁ ସେଠି ପୁରେଇ ଦେଇଛି ତା ଭିତରେ ସେଇ ଗାତ ଭିତରେ ଏଇ ଯୋଉ ରିଆକ୍ସନ ଯେହେତୁ ସେଗୁଡାକ ରାଦର ଦେଖେଇଥାନ୍ତା he was suffering from legal insanity which would have been a ground to attract the benefit which can be accused claim under section 84. But here is something different. Just go on reading that. So you are reluctant to give any reply. Yes, then?
She confessed that, but when she was repeatedly asked, she confessed that she had murdered the deceased by cutting her throat by means of a sickle and put the dead body of the deceased inside a rat hole in her bedroom. Thereafter, accused went to her bedroom and in our presence brought out the dead body of the deceased from inside a rat hole. And I found that the deceased has sustained a cut injury on her throat. Thereafter, on request of Shankar Pradhan, I scribed.
So, second thing there, you see, after committing the crime, you are taking all these steps to keep it aloof from others. You are taking steps for disappearance of evidence. You are taking steps to conceal the dead body. That shows that your mind is very okay. You are not of unsoundness mind.
That is what I am contending, that the disease that I suffer from, that is not a continuous unsoundness. That cannot be pleaded, because paranoid schizophrenia.
If it is not a continuous one, or at least at that point of time, your mental condition was okay, that goes away to consider from 84.
Since I am suffering from schizophrenia, Your Lordship.
You see, mental ailment ro जो ये रिलीफ आपन को मिलिबो आपन को सही पॉइंट ऑफ टाइम रे आपन को देखैबार अछि.
Yes, Your Lordship.
बस सर्कमस्टेंस देखैबार अछि जे तारो मानसिक अवस्था ए टाइप रो थिला. तारो जो प्रीवियस कंडक्ट पोस्ट कंडक्ट ए थ्रू जणा पड़िबो. तेनु आपनकर मेडिकल एविडेंस किछि प्रोड्यूस करछन.
Yes, Your Lordship. DW1 and 2.
Huh?
DW1 and 2.
All right, we'll go through that.
Yes.
You complete this evidence of.
Cross-examination. I was examined by the police in case twice. First on the date of incident and secondly 2 to 3 days after the incident. Swarnalata had 2 daughters, including the deceased, Your Lordship. Tappan Pradhan is my own uncle. Shrikant Datta is related to Kanu, father of the deceased. On the date of incident at about 6:30 am, I had seen the deceased was sleeping in the dori of their house. It is a fact that 1 year prior to the incident, the accused was suffering from mental illness and taking medicines. When the dead body was brought out by the accused Gitanjali, 10 to 12 persons were present. Some outsiders, except our family members, were also present, but I do not recollect their names. It is not a fact that after the accused was assaulted by the villagers and family, the accused reluctantly confessed her guilt because of the assault. It is not a fact that the accused Gitanjali had not committed murder of the deceased and she has not confessed her guilt, and that I am deposing falsehood being a relation of the deceased, Your Lordship.
So this particular line the suggestion which has been given by you to so that section 20 Evidence Act section 24 that extrajudicial confession will not be acceptable, that has been suggested in that way that after he was assaulted, he made the confession reluctantly. That has been negated by this denying the same. Rather, she has stated that when he was confronted, he was reluctant to give reply, but when she was repeatedly asked, she confessed that she had murdered the deceased so and so.
Your Lordship, otherwise also had there been any intention or any motive to do away with the child, Your Lordship, I might not have.
No, this, you see, according to you, this may not be the sufficient motive or reason to kill a child. But you cannot read the mind of a person. जो जिनसटा माँ सांगरे कली है सी कहीं छुआटा को 21 दिन छुआटा को कौन पाई मारदेव तंटी काटिदेव एटा हुए तो आपण भावी पारती से जो लोक सी को स्तर लोक को बैकग्राउंड रु आसी तार कौन माने डे टू डे लिविंग रे सी तार कौन करे सी गोटे कलीटा को को टाइप रो एक्सेप्शन नहीं जाए पारे तेणु ओवर रिएक्टिव हेई पारे इट डिपेंड्स अपन पर्सन टू पर्सन गोटे जिनस को आपण हुए तो गोटे बहुत पेशेंटली डील करि पारंती आपन किए कोन कहिला आपण बहुत पेशेंटली डील करि पारंती सेही जिनसटा को आउ का को कहबो से तो ओवर रिएक्टिव हेई कि बाडीबा को उठी आसीबो तेणु इट डिपेंड्स अपन पर्सन टू पर्सन
Also, the fact that there was a quarrel with the mother, Your Lordship,
Hmm.
none of the witnesses have stated that I ever had any quarrel with the mother of the
जा संगे कळी हेची
सी कौची जे मु कहली बट जस्ट बिफोर द ऑकरेंस मु ताकू ही जाई कि टोबैको मागिछि and I have had friendly relations with everyone. And my only contention is because of the disease that I have been suffering from, Your Lordship, I was unable to perceive what I was doing, Your Lordship. तो मु सेटा करी दे कि had there been any motive to माने जहाँ भी हे ची करिवार motive था conduct can be judged two ways, Your Lordship. As Your Lordship said, had माने intention अच्छी तो that is why I have disclosed, I have concealed the evidence also.
Intention थाउ न थाउ यदि आपण once you bring it to the case under section 84 then you are certainly you are getting the relief जे आपण गोटे जिंस करिसेंती but again 84 को आनिया को हेले आपण को जहा जहा डॉक्यूमेंटरी एविडेंस आनिया पड़िबो जहा जहा ओरल एविडेंस आनिया पड़िबो जो सर्कमस्टेंशियल एविडेंस आनिया पड़िबो ताहाले कोर्ट कारण ये दायित्वटा होची आपणकर right so burden of proof lies on you so that burden can be discharged if you brought out something from the evidence of the prosecution witnesses or by adducing defense witness by producing medical evidence all these things by you can discharge that burden ତେଣୁ ଏଠି କେତେ ଗୁଡାକ circumstance ଯୋଉଗୁଡାକ appear କରୁଛି ଆପଣଙ୍କ ଇଏରେ ଆପଣଙ୍କୁ ଯଦି ସେଇ ଗୁଡାକ ସବୁ circumstance କୁ ଯଦି accept କରାଯାଏ first one is the recovery of the dead body from inside your bedroom from a rat hole that is number one. Number two, bloodstains were there in your bedroom. Number three, your sari was stained with blood. Number four, the weapon of offense was lying inside your bedroom. Number five, that weapon was seized and it was sent to the doctor. Doctor said that the injury which has been caused to the deceased was possible by that weapon. Number six is that weapon contains human blood, of course, group not detected. And the most vital aspect is that you made extrajudicial confession before three witnesses, at least before PW6, it appears to be more reliable. Because by thereafter, some evidence has been brought on record that you were tied. So keep all these things in mind and also the citations which are there under section 84 and how you can successfully discharge your burden because what it says, section 105. Yes, 105 illustration A. A accused of murder alleges by reason of unsoundness of mind, he did not know the nature of the act. The burden of proof is on A. So this burden of proof, how you have discharged? By adducing what evidence? So 84, keep in mind section 84 IPC, section 105 of the Evidence Act, and what the evidence are available on record, right? So that even if the prosecution case is proved that you have killed the child, you have concealed the dead body inside you have made extrajudicial confession, still then, if you can bring your case within the purview of section 84, you can succeed in view of the settled position of law. For that, what have you brought on record? So today it is already time. We'll take up this matter tomorrow.
Yes.
Well, pardon to mention one appeal under against conviction matter for 7 years. No bail matter. And another SCST bail matter.
Well, appeal for bail. Election cases. Appeal for bail. Another is tied up matter. Appeal for bail.
Tied up matter.
That's a criminal appeal for fresh admission. Criminal appeal for bail.
Tied up bail matter.
Appellant already sustained 8 years of conviction. My lord. One of the co-accused granted. Last week, your lordship allowed the memo, but it could not be listed.
Only it come
Tied up matters.
June.
Pardon me, Lordship. BL appeal number 3927 of 2023. Lordship, I filed an entry application on the ground of the mother of the petitioner was ill, your Lordship. On 18/12, Lordship called for the instruction, your Lordship. After that, the matter was not listed, your Lordship.
Give the memo. It will come.
Another is CRL number 94 of 2023, conviction matter. Out of 10 years of substance sentence, the appellant was custody more than 8 years, Lordship.
Give it.
Pardon to mention, my lord. My lord, may I mention BAPL number 7166 of 2023. My lord, in this bill application, we have filed a IA number 937 2023 for interim bail on as the wife of the petitioner is not well. My lord, she is suffering from critical issues. My lord, kindly list this matter next week.
Note it down. It's noted. Yes.
Obliged, my lord.
My lord, election matter is posted to 25th for my reply.
Right.
I have shifted from Bhubaneswar to Kotak.
Okay.
Office is not in order. I will give reply on 29, 30 and 31.
You are to conclude it by 31st. That was the order, na?
Yes, my lord. Within that time I will conclude. And after your lordship allowed it, I will convey it to my election petition.
Okay. So Mr. Kanungo is not here, and
I will inform you.
You are.
My lords, I will convey senior my lords.
You are the associate of
My
Mr.
lords.
Okay, his associate is here, and you will convey. So it will not be listed tomorrow. See that it is not listed. Yes.
Much obliged.
Supplementary list, item number 1.
Replacement. On 17/1/2024. On 17/1/2024, the instruction was sought for regarding the documents attached to the interim application number 75 of 2024.
for
It's the extension of interim bail.
Yes, my lord. On the ground of the examination of the son of the petitioner is scheduled to be held, I have annexed the program schedule, my lord, in my
What exam?
+2 annual +2 exam. And the lordship directed for taking
When that exam commences?
It will commence on 16/2/2024.
16/2 ରୁ 13/3 ପର୍ଯ୍ୟନ୍ତ.
So you have documentary proof
Yes.
you have given that
Yes,
that you are appearing the exam.
so your lordship directed to take instruction regarding the genuineness.
Consular report, Mr. Right, IA number 75 of 2024. This is an application for extension of interim bail order dated 16/10/2023 on the ground that the son of the petitioner is supposed to appear the final year of +2 science examination from 16 to 2024, which is supposed to continue till 13/3/2024. And the presence of the petitioner is very much necessary during the said period of examination. Copy of the registration card of the son of the petitioner, so also the program of the examination have been attached to the interim application. The Land and Council for the state was asked to obtain instruction on the interim application. Today, the Land and Council for the state has produced written instruction dated 24/1/2024 received from Inspector in charge of Kuliana Police Station to the effect that the principal of the school stated that the son of the petitioner is continuing his studies as a student of +2 second year science, and the annual higher secondary examination 2024 is going to start from 16/2/2024 to 13/3/2024. And the principal has also certified that the document produced by the petitioner is true. The latter is taken on record. Considering the submission made by the Land and Council for the respective parties, the averments taken in the interim application, the document annexed to the interim application, the written instruction received by the Land and Council for the state, the interim order dated what is that order when it was passed for the first
16/10/23
interim order dated 16/10/2023 passed in miss case number
739.
miss case is IA number.
No, my lord, miss case.
Miss case,
in
acha.
this seven-
Miss case number 739 of 2017, which was extended till 25th January 2024 as per order dated 17/1/2024 in IA number 75 of 2024 is further extended ए मार्च मास से ये पड़ा कैलेंडर कौन है आप रखी इस साइड को रखना कितने सरीब सेटा
13/3/24
13 टा होची बुधवार एटा होची बुधवार extended till 17th of March 2024 and the petitioner shall surrender before the learned trial court on 18th March 2024. Matter be listed in the week commencing from 2nd April 2024. The learned counsel for the appellant shall produce the surrender certificate of the appellant. Yes.
In course of day, madam?
Yes, yes, course of day. Later, नहीं ये hearing चलो से तो पड़ेगा
Bill is for his wife's illness. Is suffering from carcinoma, a type of cancer.
So, Mr.
Yes, I have received the instruction.
What is the instruction? So, Mr. Tripathi, it's a genuine case, as it appears. Right. IN number one. So, this is an application for interim bail. This interim application has been filed on the ground that wife of the petitioner having serious gynecological problem and surgery is required to be done. And for such purpose, the presence of the petitioner is very much necessary. Medical documents have been annexed to the interim application. Learned counsel for the state was asked to obtain instruction on the interim application. The learned counsel for the state has produced the written instruction received from SI of Khandagiri Police Station dated 2/1/2024, from which it appears that the medical documents are genuine and the petitioner's wife is suffering from serious gynecological problem, and since her health condition became critical, the medical officer of Raj Hospital and Research Center, Bhubaneswar, referred her to SCV Medical College and Hospital Cuttack for better treatment. The written instruction is taken on record. Considering the submission made by the learned counsel for the respective parties, the averments taken in the interim application, the written instruction produced by the learned counsel for the state, I'm inclined to release the petitioner on interim bail for a period of 1 month from the date of release. Yeah. IA is disposed of.
Obliged. Item number 3.
Please, your lordship.